File 4284, Senator Seeberger, and we'll invite Superintendent Evans to come down as the testifier on this one. Senator Seeberger, why don't you tell us about the bill?
Thank you,
the plan is to lay this over, by the way.
Thank you, Mr. Chair and members of the committee. I'm here on Senate File 4284, which is a BCA policy bill related to the work of the BCA Financial Crimes and Fraud section. The bill would provide additional tools to the BCA in its fight against all types of fraud in Minnesota. This bill adds subpoena authority in fraud investigations to allow BCA to obtain certain records and enhance its ability to investigate fraud. This bill also expands identity theft to include AI or technology-based duplication of someone's likeness and extends the statute of limitations for some types of fraud-related crimes. This extension is important due to the complex nature of these crimes and helps ensure fraudsters are held accountable. And I have with me Superintendent Drew Evans from the BCA to provide more information about this bill.
Superintendent Evans.
Thank you, Chair Latz, and thank you, Senator Seeberger, for carrying this bill. As Senator Seeberger noted for the committee, my name is Drew Evans, and I'm Superintendent of the Minnesota Bureau of Criminal Apprehension. This bill will assist us in combating fraud across Minnesota. The BCA operates the Minnesota Financial Crimes and Fraud section, and their purpose is to investigate traditional financial crimes, wage theft, insurance fraud, and then state program fraud. As we continue to do our work across all the work you've been doing to combat fraud, there are a couple of provisions here, as noted, that will assist us in our work. The first being additional subpoena authority to subpoena certain records that we're looking for in these processes. This will assist us to move fraud cases through the system more quickly, in particular with other state agencies when there's records that might have varying different legal authorities. Even though you've done a lot to work on that already for information sharing, it gives us additional tools to do that, to subpoena those records. The second piece is really getting in front of what is a growing trend we're seeing across all types of fraud, is including and expand the definition of identity theft to encompass wrongful use or duplication of a person's voice or likeness, including their forged digital likeness. So I'll give you an example. It wasn't in Minnesota, but it was at a recent meeting where an individual was enterprising, utilized AI to apply for a job. They were hired by a job, and then they committed workers' compensation fraud all through AI. The person never existed. And in our digital age, and we're working in, these are the types of things that we want to ensure we're in front of. And then the last one is extending the statute of limitations for certain fraud-related crimes that are delineated out in the bill. These are the most typical crimes that we're charging individuals with for frauds. It is not unusual for us to take several years to investigate a fraud due to the complexity and the nature of some of these schemes and the volume of records that we often need to look through and obtain to be able to prove the fraud. And so this would be moving most of these crimes from a 3-year statute of limitations in most instances to a 7-year to ensure that we can hold people accountable in those situations when they do commit fraud. And with that, I'd be happy to answer any questions of the committee, Mr. Chair.
Any questions for Superintendent Evans? Senator Holmstrom.
Thank you, Mr. Chair. Do any of these provisions address the types of fraud we've seen, like in HHS, what most of us are referencing when we talk about the rampant fraud?
Superintendent Evans.
Chair Latz and Senator Holmstrom. So all of these are designed to combat those types of fraud as well. I do want to be clear for the committee. The BCA's role in some of these frauds is to conduct the criminal investigation when it comes to these. There's also a fraud mitigation component, but the statute of limitations is one component. Those are crimes that when you're referencing the Department of Human Services and some of the Medicaid fraud cases that would be there, these are some of the provisions you use in addition to some of the other pieces that are there. I should note, just to be clear for the committee, we provide assistance to the Medicaid Fraud Control Unit, which is within the Attorney General's office, and we've been expanding that partnership as you've seen some of the number of those cases, but they retain the primary authority and jurisdiction over those particular cases, but all three of these would assist us in those various types of fraud that you're referencing.
Any further questions? Not seeing any. Senate File 4284 is laid over. Thank you. Next up, Senate File 4206, Senator Seeberger.
Thank you, Mr. Chair and members of the committee. I'm here today on Senate File 4206. This bill would create new statutory language to make it a crime to create, use, or display fraudulent DNR licenses, watercraft, and recreational vehicle registrations or permits. This would enhance DNR statutes, improving the agency's ability to address this emerging type of fraud that they're already encountering among fishing and hunting licenses, permits, and registrations. These enhancements are necessary to address advances in technologies such as AI that enable individuals to create fake licenses, permits, and registrations that look very similar to real DNR licenses and registrations. The fees from licenses, permits, and registrations go back to maintaining and protecting our natural resources, so people who create fraudulent documents essentially are stealing from the people who do things right and are making it harder for the DNR to ensure future generations, or all of us, to ensure future generations have the same opportunities that we do today. The changes in this bill would create a new statutory language to make it a crime to create, use, or display these fraudulent licenses. In addition, it would make it unlawful for recreational vehicle or watercraft dealers to intentionally register or permit these vehicles incorrectly to either save money or allow them to be used in an unlawful manner. Right now, it is not a crime to make, display, or pass off fraudulent DNR licenses, registrations, and permits. At the same time, it is unlawful to try to pass off someone else's valid license as your own. This bill addresses issues we currently encounter and positions us to address emerging types of fraud. With that, I will turn it over to my testifier who can provide additional information and examples they are encountering across the state.
Okay, Senator Seeberger, hold on just a second. We're going to get some paperwork clarification here.
Standing by.
So just in case people are wondering, we had the wrong bill passed out, so we're waiting to get the correct bill in front of the committee before we proceed.
But they're just trying to face the kickers.
Not everybody got one. Do you want to check one there? Should we got one? Okay. It's a DNR.
Okay. Everyone has the right bill?
I guess everybody but you.
Really?
It does, yeah.
Story of my life, everybody got the right bill except me. Oh, you didn't get, okay. Senator Oumou Verbeten and I are in the same boat on this one.
Let's pass.
You know what I'm going to do? Because of that and that flip comment by Senator Limmer, I'm going to invite Senator Limmer to take the gavel for a little while. Would you do us the honor, Senator?
Does everyone have it?
Scribbled on it.
I did that.
Oh, you did that. Well, then you can continue.
All right.
We can make that a
Does everyone have the bill in front of us, number 4206? Great. Senator Seeberger, could you encapsulate what this bill is again? I'm sorry to have you repeat it all, but it'll give us better context with the proper.
I will not repeat it all, Mr. Chair or
Thank you.
Senator Pappas. This bill simply creates statutory language to make it a crime to create, use, or display fraudulent DNR licenses, watercraft, and recreational vehicle permits. Currently, it's not a crime to do that. We know that AI can do some amazing things, which includes creating fraudulent DNR licenses. So I would like to invite my testifier to offer a little bit more insight onto this bill.
Please identify yourself for the record and then proceed with your testimony.
Thank you, Mr. Chair, members of the committee. For the record, I'm Lieutenant Colonel Robert Gorecki, Assistant Director of Enforcement for the Minnesota DNR. The DNR supports Senate File 4206, which addresses gaps in current state law related to fraud of natural resource type licenses, registrations, and permits. This bill addresses issues we're currently seeing in the field as a result of technological advances, and also positions us to address future fraud-related licenses when it comes to DNR-related activities. With advancements in artificial intelligence, we are seeing an increased number of incidents that involve people using AI or other means to create fraudulent licenses, recreational vehicle and watercraft registrations, and permits such as state park permits and passes. This is problematic for many reasons. Amongst them is lost revenue from the sales of these licenses, registrations, and passes that are vital to the maintenance and the protection of our natural resources. This bill would comprehensively address all known DNR-related fraudulent licenses, registrations, permits, and passes in order to deter and reduce these emerging types of fraud. A few examples that we're seeing in the field: creating and using fake licenses or registrations, such as hunting or fishing licenses with GPT and others. You can create a license that looks very similar or nearly identical to licenses we have. Purchasing and using duplicate licenses, essentially making copies of valid licenses that are fake or already been used and trying to pass them off as real, or purchasing multiple shelter licenses for such as a fish house or things of that nature, making duplicate copies of those and then putting them on multiple houses, such as if you were a fish house rental business or something like that. This bill also addresses commercial dealers who are knowingly registering recreational vehicles incorrectly in order to use them to operate in places and manners that would otherwise be unlawful. For example, registering an off-road vehicle that meets the legal definitions of an off-road vehicle as an ATV, so then you can use them on ATV trails or other places that off-road vehicles would not be allowed. We're also seeing recreational vehicles and watercraft dealers issuing temporary vehicle registrations, which are intended to be used for newly purchased registrations for watercraft and ATVs, such as like the 21-day permits or stuff like that that you would get when you purchase one. They're using them, giving them out to their family members or friends, and then to use these vehicles, return them back to the dealership and simply rip them up with no intention of ever purchasing them. The DNR has reached out to numerous natural resource user groups, including MinUSA, which is the Snowmobile Owners Association, ATVAM, essentially the ATV, and Minnesota Four-Wheel Drive Association, and the National Marine Manufacturers Association, and they've all expressed their support for reducing and preventing fraud that has a fiscal impact on our state. So the DNR thanks the author for this bill, which ultimately will assist us in reducing fraud and preventing it, and ultimately holding people accountable for their actions. And for that, I'll stand for any questions.
Is there anyone else in the audience who wishes to speak for or against this bill? I see none. We'll open it up for discussion. Senator Holmstrom.
Thank you, Mr. Chair. I understand AI might help people generate the image. How are they getting past the proprietary paper that it's being printed on?
Yeah, Mr. Chair, Senator.
Colonel Gurecki.
Thank you. So let's take for an example of a boat, for example. They can duplicate the image and then slap it on the side of their boat with like packing tape. So if an officer goes by at a distance, it looks very similar to what we have. It's only upon actually checking our records, if let's say there's an enforcement contact, that we realize that the registration is no good or it's fraudulent, or maybe there's very minor imperfections that officers are seeing and then identifying them. So,
Senator Holmstrom.
Thank you, Mr. Chair. Second question I have is a couple places in here. It says that it's going to be, it's trying to make a false statement related to an application for a state park permit or any type of permit a misdemeanor. What do these applications look like? I'm not sure if I remember filling one out. Is it just name, address, or are they providing more important information?
thank you, Mr. Chair. Senator, so that
Colonel
would come,
Gurecki.
thank you. That would get into like residency type fraud issues where maybe non-residents are trying to falsify an affidavit saying that they're a Minnesota resident or things such as that.
Senator Holmes.
That's all. Thank you.
Senator Kroon.
Thank you, Mr. Chair. Kind of surprised to hear in the testimony that this isn't already illegal. Couldn't this fall under existing law in some capacities? And I just started doing a quick search while we were talking, and one example could be 609.625, which is the forgery statute, which I think, just looking through this definition, would cover falsely creating a public issued document. Why is existing law insufficient to address the types of situations that you testified about?
Colonel Gurecki.
Mr. Chair, Senator, yeah, that's a great question. So we've had numerous incidents where we have attempted to try to get charges from county courts and judges. County attorneys are saying that because it isn't in our DNR related type statutes, that they will decline trying to charge those out, that we would need to enhance our stuff to not only have it for every single type of license, hence why you see the copy and paste, if you will, over the various types of recreational vehicles that we have. So because of the recommendations from the county attorneys and judges, that's why we're coming back. We thought it was also covered under some of these, and unfortunately we've been told it isn't. Just trying to make it clear.
Any further discussion? Senator Oumou Verbeten.
Thank you, Mr. Chair. I just wanted to clarify, are there penalties for the companies that are creating this content in the bill? And then if so, where would if there were financial penalties, where would that money go?
Colonel Gurecki.
Mr. Chair, Senator, no, as of right now, in this bill, there's nothing for these artificial intelligence type companies. However, obviously the recreational vehicles dealers obviously have penalties in here, but nothing for the companies that would create the licenses in theory.
Any further discussion?
Mr. Chair?
Any further discussion? Senator Latz.
Mr. Chair, I'm trying to see if there's a different perspective on this bill sitting to your right but I can't find any, so that's all I have.
Senator Latz, we have a very busy schedule today. We're trying to get out of here by 3 o'clock. I did have a question myself. In looking at the language of the bill, there's some references to knowingly committing an act and other provisions. We're not even going to get there, Senator Pappas. But there are some references that omit the knowingly or willfully, and I was wondering if that was intentional. And it seems to permeate through every section of the bill. I had counsel look it over, and I don't know if he has an opinion in it or not, but willing to hear his reaction.
Mr. Chair and members, I think that is, that's a policy choice for the committee to make, whether you think they all should have a mens rea state and what that should be.
Colonel Gorecki?
Mr. Chair, thank you. So we thought it was very important that people are doing this intentionally and knowingly for all of these. There's sometimes people that make mistakes when they register their thing or they buy the wrong license accidentally, and it's on the state to prove that they did it intentionally.
Colonel, if I could direct you to page 1, line 12. There's a simple statement to issue, obtain, or use a dealer. Temporary 21 registration permit, but then on line 115, we have the knowingly. Back on line 12 and 13, without the intent, there is a qualifier there. And then on line 17, there is none. So I'm just wondering if that was an error in scribing it or if it was intentional.
Mr. Chair, I would say that line 12, 1.12 shows that they have no intent. It is using that word instead of knowingly. I mean, if they have no intent, they're using them incorrectly. But certainly, the intent of this was that they knowingly are making mistakes. So if you're so inclined to edit or change.
And then on line 1.17, there is no reference to knowingly or intent reference.
Yes, Mr. Chair.
Does that need that?
I don't believe so, because it's a fictitious license, something that was made up. So I think that in and of itself would show that you did it intentionally.
All right. Thank you. Any other discussion? Seeing none, this bill will be laid over. Thank you.
Thank you, Mr. Chair.
Senator Seeberger. We'll now move on to Senate File 4843.
Still me?
Senator Seeberger.
Thank you, Mr. Chair.
It's being passed out.
Okay.
So if you give it a moment.
This is what we talked about Wednesday. This is the agritourism.
Okay.
And so they come up with language amendments.
Senator Seeberger, I understand there's an A1 amendment that's an author's amendment. This is the first hearing in the Judiciary Committee.
That is correct.
So Senator Seeberger moves the A1 amendment as an author's amendment. All those in favor say aye.
Aye.
Aye. Opposed? The amendment is adopted. Senator Seeberger.
Thank you, Mr. Chair. I am back before you with Senate File 4843, which we heard on an informational basis earlier this week, whatever day that was, Wednesday perhaps. This is the bill that adds the off-road vehicle trails to the definition of agritourism activity. The amendment that we just passed represents an agreement between some of the stakeholders and makes the language a little bit clearer within this bill. We went through it quite extensively on Wednesday, but happy to answer any questions the committee may have.
Is there anyone in the audience who wishes to speak for or against this bill? Seeing none, we'll open it up for discussion. Hearing no discussion. Senator Clark.
Thank you, Chair. Senator Seeberger, just to be clear, this is all about immunity and not adding, these are types of events that are already occurring. And so this is just making it clearer for the purpose of insurance and immunity within that, that it is clear that it's allowed and acceptable.
Senator Seeberger?
Thank you, Mr. Chair. Senator Clark, I'm going to correct you slightly. We're talking about a limitation of liability, not immunity. For all the purposes that we discussed on Wednesday, yes, you are correct.
Any further discussion? Hearing none. Senator Seeberger moves that Senate File 4843 as amended be recommended to pass and lay it over. All right.
Fantastic.
Long way to get there. Senator Westlin. Senate File 4843. And the bill is being passed out at the current time. Oh, I'm sorry, we're moving to 4301. Senator Westlin, while the bill is being passed out, would you want to describe your bill? Oh, and you have an author's amendment as well?
I do, Mr. Chair. I would like to offer the A4, which is a DE amendment.
Senator Westlin offers the A4 amendment, author's amendment. This is the first hearing in Judiciary. All those in favor say aye.
Aye.
Opposed? The motion is adopted. Senator Westlin.
Thank you, Senator. This is technically the second hearing on this bill, but this is one that we were discussing late at night last Thursday when we were here until 11 o'clock. You will recall that there was a bill that was brought forward. This is the Domestic Violence Task Force bill. There were some questions raised, and since that time, additional work has been done on this bill that has resulted in the DE amendment. We did have a considerable amount of discussion at the hearing the other night, so I think what I will do is focus primarily on the changes that have been made and just let folks know that there are still some ongoing conversations, and I think the path for this is that it would be laid over for the omnibus, and there may be some additional changes in the conference process. So let me just walk through and highlight the differences between the DE that we just adopted and the bill that we heard last week. These changes are the result of discussions with stakeholders, especially and including the Minnesota Council of Criminal Defense Lawyers. Section 4 of the revision extends the time frame for law enforcement to make arrests in non-felony cases from 72 hours to 28 days. I will just say that based on some conversations with MACDL, that is one provision that may be subject to some additional conversation and change. It also does state that should there be probable cause that a person has harassed or stalked an individual, committed domestic abuse, or violated an order for protection, and if they were not arrested, then the peace officer should seek a warrant from a judge. Section 6 amends much of the language that we talked about on March 19th. This section states that an individual charged with a violation of an OFP or a no-contact order, they must be detained until the person's first court appearance. And again, this is for a violation of an OFP. Additionally, in cases of harassing or stalking any person or harassing or stalking any person or for domestic abuse, the officer or sheriff shall issue a citation in lieu of continued detention unless the officer or sheriff determines that the person poses a threat to the victim or family, public safety, or substantial likelihood the person will fail to appear. And in making that determination, they are directed to consider the following factors. Any prior arrest or conviction for harassing, stalking, domestic abuse, or violations of OFPs or no contact orders, any OFPs, harassment, restraining orders, or domestic abuse, no contact orders that the individual is a subject of, and any pending OFPs or harassment restraining orders in which the person is a respondent. Section 7 involves the judicial review for bail and release. Again, there are changes here from the version we heard on March 19th in this section. In cases concerning a violation of an OFP or a domestic abuse no contact order, also known as a DANCO, the prosecutor or prosecutor's designee must describe the allegations in the underlying petition or criminal case. And then additionally, in making a decision regarding pretrial release conditions of a person arrested for domestic abuse, stalking, violation of an OFP or DANCO, the judge shall, to the extent possible, make findings on the record that describe whether the individual was previously arrested for or convicted of harassing, stalking, domestic abuse, or violation of an OFP or DANCO. The court should make findings as to whether the subject of an OFP, DANCO, or harassment restraining order, or if they have been a subject of those, and if so, the nature of the allegations that give rise to the order. And then lastly, is the respondent for an OFP or harassment restraining order, and the nature of the allegations of those petitions that are pending. And then the other major piece of this is that the section relating to the task force has been removed because that would have precipitated a stop to another committee. And so this is the bill as it has been changed since the last time we were here. And we do have testifiers for the bill.
Senator Westlin, would you want to introduce your testifiers and have them come to the table?
Certainly, Mr. Chair. Why don't we start with Jana Williams, and if Jess Paulian is, why don't they come to the table? And then I think Mr. Carlson is here to answer questions, I think.
Ms. Williams, welcome to the committee. Would you first identify yourself and then proceed with your testimony?
Okay. Bonjour, my name's Jana Williams. Thank you, Chair Limmer and members of the committee. I'm here today as an aunt to a niece who was murdered by a man she loved. Her name was Allison Lucier. Many of you have heard her name, and if you have, then you know her story is not just about one moment. It's about repeated failures. Failures by systems that were supposed to protect her, not just in her final hours, but throughout her life. Allison did everything we tell victims to do. She called 911 multiple times. She filed for orders for protection. None of them were ever served on her abuser. But today I'm here to talk about one failure, one law that could have saved her life, the 72-hour state statute. I've told this story so many times over the past 2 years that it becomes repetitive to me. But you need to hear it, because this is exactly how the system fails victims. On Tuesday, February 13, 2024, around 6:30 p.m., Allison let her abuser into her apartment. He began beating her, he strangled her, he stripped her of her clothing as a form of control because he knew no victim wants to run naked for help. And still she ran. She ran to a neighbor's apartment. They called 911. 2 officers responded, but her abuser was gone when they arrived, GOA, gone on arrival. They told her, if he comes back, call us. We'll come back and we'll arrest him. But you only have until midnight on Friday to do so. Midnight, a deadline on her safety. Just after midnight on Friday, February 17th, Allison returned to her apartment. She heard someone inside. She knew it was him. She ran again to another neighbor's apartment. They called 911. The same 2 officers that came on Tuesday came on Friday. This time they found him inside of her apartment, and Chuck, her abuser, told them he was just picking up a few of his things. So they let him go. No arrest, no protection. The next day, Allison was dead. I watched the body camera footage myself. I listened as those officers explained to her why they couldn't arrest him, because it was 32 minutes after midnight. 32 minutes past a deadline that should never have existed. This is what we are asking victims to survive, not just the violence, but a clock. Abusers know this law. They know they can disappear for 3 days and wait it out and come back without consequence. That is not justice. That is a loophole, and it's deadly. Every generation says that we want to leave the world a better place for their children and grandchildren. Today, we have that opportunity to actually do that. Extend the time, remove the barriers, close that loophole, because the victim should not have an expiration date on protection. And no family should have to stand where I stand asking why the system ran out of time before it ran out of chances to save her. Other provisions in this bill will help address other system failures that have had fatal consequences, and the research parts of this bill will help our state make informed decisions in the future about the best way to prevent and respond to domestic violence. Let Allison's story be the reason this changes, and let's make this a better world. Maye Quade.
Thank you, Ms. Williams. On behalf of our committee, we want to extend our sympathies for your loss.
Thank you. I appreciate that.
Mr. Pallion, would you identify yourself for the record and then proceed with your testimony?
Thank you, Chair Latz, or Chair Limmer. My name is Jess Pallion. I am the Policy Program Manager at Violence Free Minnesota. We are the statewide coalition to end relationship abuse, and I am just here to help answer questions on how these changes may help victims and survivors of domestic violence.
Thank you. Senator Pence.
Thank you, Mr. Chairman. We've been doing legislation on domestic abuse for a long time, and I'm just kind of surprised that this 72-hour thing hasn't been changed before. Do you have any sense of why that is? Asking the witness.
Mr. Pallion.
Yeah, I'm not certain why we haven't made this change in the past. This has been an issue that has come up for a few survivors, including what happened to Allison Lucier. I know that some of our neighbor states don't have this. For example, Wisconsin doesn't have any limitation on warrantless misdemeanor arrests, but I'm not sure why this hasn't been changed in the past.
Thank you.
Any other discussion? Is there anyone else in the audience who wishes to speak for or against this bill? Please come up to the testifying table. Would you identify yourself for the record?
Yes. My name is Ryan Alvar, and I'm here not for or against this bill, but to speak about how we need to take this seriously in the state of Minnesota.
Could you pull the microphone just a little closer?
You see me here every day. I'm advocating for family court reform. Because our judiciary system, we do not have due process. And we are not taking mental health seriously. And that's what brings me to this bill today.
Mr. Albert, could you keep your comments directed to the bill in front of us?
Yep, I am. I support victims of domestic violence. I am a victim of domestic violence. I'm a father trying to protect my children who are victims of domestic violence. But what concerns me is how we're defining abuse and what framework we're using to do it. In the support letter for this bill, Violence Free Minnesota references Minnesota as the birthplace of the power and control wheel and the Duluth model. Many people in this room do not fully understand what that means. So let me explain it plainly. The Duluth model is a framework used to train law enforcement, courts, and agencies, not just in Minnesota, but across the country and around the world. It's built around something called the power and control wheel, which breaks domestic violence into categories like emotional pressure, isolation, controlling finances, limiting access to children, and intimidation. The idea is that these behaviors reflect on a broader pattern of power and control in a relationship. At its core, this model teaches that domestic violence is not rooted in mental health, but in learned power and control behaviors tied to bias. In fact, I have a 2014 Minnesota appellate case. The director of that model stated, and I'll read from that transcript, "Battering is not a mental health issue. It's a learned behavior like racism, like sexism, like classes and things that we learn about bias as we grow. The work we do with the men in classes is to help them understand what bias is, what they have about women, and help them find a way to live non-violently with their family. That philosophy matters, because if you build laws and systems on that foundation, and you're intentionally removing mental health from the equation, and that's important to understand something about that framework. The power and control wheel was originally designed around very specific structure, a male perpetrator and a female victim. And the training that comes from that model reflects that structure, focusing heavily on re-educating men about their beliefs and behaviors towards women.
Mr. Albers?
Yes.
You really need to keep your focus on the bill. We have a lengthy agenda today. You're speaking more in generalities than you are on the bill. If you could keep your comments directed toward the bill, for or against, I'd appreciate it.
Yep, I'm trying to, yep. As you witness me sitting here every day, in committee meeting after committee meeting, we hear something. And that something is mental health is one of the biggest crises we face. So how can we say that in one room and then pass laws in another that ignore it entirely? This bill expands domestic abuse to include someone's feels, fear, intimidation, oppression. But feelings are not facts. Feelings are influenced by trauma, anxiety, stress, and mental health concerns. And if we don't account for that, we risk misidentifying situations, escalating conflict, and making the wrong decisions for families.
Mr. Albers, are you for or against this bill?
I am for the parts that take real, fact-based due process. I am against the portions that are arbitrary, that do not reflect our due process rights. They make decisions based on feelings and not clear and present evidence before the court.
Okay.
When we don't take mental health seriously in the state.
Mr. Albers, one of the areas that you're talking about right now has been deleted from the bill. We're now on a delete everything amendment.
Okay. That was just received now?
Yes.
Okay. This is all based off of what was on an hour ago.
Okay. This bill will be laid over.
Okay.
It'll be going to, oh, it will not be? Senator Westlin, what's your intent?
So,
the direction of the bill?
Mr. Chair, I think that our intention is actually to pass it to the floor, and I think its potential would be to be in the omnibus as well. I think it's another one we probably want to try to dual track. And as I've mentioned, there are ongoing conversations, and either as part of the policy omnibus or a bill going to the floor, there are likely to be one or two more tweaks to this bill, but I would like to keep it moving.
All right. Senator Albers, could you sum up your comments briefly, and we have to keep moving on the agenda today.
Yes. Not having the amendment in front of me that was just handed out, I just want to end with where we've gone with trying to solve domestic violence hasn't worked in the state. We're pouring water on smoke instead of putting out the fire. I thank you for your time. Thank you for your consideration in figuring out mental health in the state, and part of that is solving this domestic violence issue we have. And I'm sorry for everyone here. I'm sorry for everyone that's testified, that has lost loved ones, and I know we can get together and fix this. Thank you.
Thank you, Mr. Albers. If you wish, you could put your comments in writing. I'm sure all of us appreciate your more expanded version of the bill.
Thank you, Chair.
Thank you. Is there further discussion? Senator Oumou Verbeten.
Thank you, Mr. Chair. Thanks for bringing forward the bill, Senator Westlin. Really appreciate our testifiers as well for sharing those stories. I appreciate so many of the pieces that are included in here, and I know one of the other things we've been working on is making sure that when there are suicides, overdoses, accidental deaths, and there's that history of domestic violence or abuse, that there's a review. And I think we're waiting on jackets from an author on that bill, but it's very much related to the discussion we're having today. So just want to name that for the committee, and that's work we'll have to continue to do to ensure justice for our victim survivors. Thank you.
Senator Latz.
Thank you, Mr. Chairman, and Senator Westlin for bringing the bill forward. I mean, it addresses a real problem, and I appreciate what you're trying to accomplish here. I know we've had some conversations offline about this, and I know you're in ongoing conversations with the other body as well and stakeholders. I noted when this bill was brought to us before that there were an important category of stakeholders that had not been part of the apparently year-long process, which led to this bill, and that was the defense bar, and the public defenders and the Minnesota Association of Criminal Defense Lawyers, which are the only ones in the system whose fiduciary duty is to look out for those who are accused of violating the laws. And so I thought it pretty important to get input from those groups here. Their input has been received, and some of which is reflected in the amendment that was here today. So I appreciate that. One of the bits of input had to do with a concern that I had raised, which was the appropriateness of arresting absolutely everyone and holding absolutely everyone until court who is alleged to have violated any of the protective orders that are listed in the bill. And the amendment that we now have before us creates two different categories. It says two of the categories of types of protective orders that are in there. It's still an absolutely automatic hold for court regardless of the nature of the alleged violation. And then there's the other category applying to some other protective orders, which says you don't have to hold them for court, but you may hold them for court. Law enforcement makes that decision depending on, and then it itemizes a couple of criteria, including history, the behavior that is alleged, whether there are priors of the similar nature, that kind of thing, which I think are really helpful criteria to factor in here. My thought is that those criteria should be used in every case, not just carving out those for certain protective orders, but not for other protective orders. Some violations are absolutely obvious, that the allegations are a serious threat to the safety of the individuals that are protected by the orders. Others, it's far less obvious. A single text, a missed phone call, kind of thing, which could be a pocket dial or it could be an intentional call. One call versus a series of calls in 15 minutes, for example, could signify different situations. Driving by a residence versus knocking on the door, or driving within a few blocks, because sometimes protective orders say stay away 3 blocks. But if a person's in transit to some other legitimate location, that's the only route to get there, then you could have a violation nevertheless. And under the law, under the way this is proposed, they would automatically be held for court, even if it happens on a Friday night and court doesn't occur until Monday morning. And then depending on how busy the court is, it might happen Monday morning, Monday afternoon, even Tuesday morning. And in the meantime, someone can lose their job or miss important family events as well. And the reason I'm saying this is we can sit here and conjure up hypotheticals all day. I see this stuff every day. I see the worst, and I see the not so bad allegations of violations. And I don't think a one-size-fits-all rule or law works in these kinds of situations. So I think not every county has judges on duty for Saturday morning, for example, that will review all the custodies and look at the allegations and determine if it's appropriate to release someone on bail or not on bail with a return court date. Or some counties that do have those judges on duty, as a matter of their practice, will never release anyone on a Saturday morning when the allegation is something like this, regardless of the nature of the particular facts that are involved. So I'd be much more comfortable leaving it to the discretion of law enforcement to make a judgment call on that. and maybe not decide to hold someone until the next available court hearing. So I know those conversations are ongoing, and I'm going to vote to pass the bill out of committee today because I think it's important to keep this process moving forward. But I'm going to reserve judgment on the total bill until we see what comes of those conversations with others in the process. The other thing that I was looking at was the change in the 72-hour provision. I know the original bill proposed an indefinite provision, which would have meant that law enforcement could, without a warrant, without judicial review, without any finding of probable cause by an independent objective jurist, arrest someone at any time in the future. 24 hours later, 100 hours later, a month later, a year later, they could be subject to an arrest. Now, this is addressed in two different ways here, as I see it. One is the requirement that a law enforcement officer promptly get a warrant, present a warrant request to a judge to issue a warrant so that it can get that objective judicial review to determine if there is probable cause for that arrest, rather than just leaving it on law enforcement to make that decision. But then the second thing is, what's the appropriate time frame? And I respect the testimony earlier that there should be an expiration time on safety. On the other hand, how long is too long to leave a non-warrant type of arrest potentially hanging out there? I don't know what the magic number is. It's proposed in here to convert it to, 28 days, I think it was. I know that the Association of Defense Lawyers has suggested 7 to 14 days. Pick a number in there, maybe 7 or 14. How long is long enough to make sure that maybe they can access someone, or at least there's enough time to get a warrant? It would seem to me it should be long enough to get a judge to issue a warrant. If a judge declines to issue a warrant, then there was no ongoing basis.
Right.
As a practical matter, in almost every case, a judge is going to issue a warrant. There's almost always probable cause based on an officer's submission of facts. Certainly 7 days, no doubt 14 days is long enough for a judge to issue a warrant. There's at least 1, maybe 2 business weeks involved there, and judges review these matters promptly. So it seems to me that'd be a more appropriate number than even 28 days. Then it's not a matter of waiting out a time period. Once the warrant's out there, there is no time period. The warrant stays active and valid until the person's arrested. So to me, that's the backstop, is the judicial review, and that 7 or 14 days would be more than enough time to obtain that judicial review. It would accomplish the intended goal, which I support, which is to promptly arrest an individual that is alleged to have violated these protective orders, because they're very, very important that they be complied with. But it also provides that additional backstop, if you will, or constitutional review by a judge to make sure there is, in fact, ample probable cause. So those are my 2 areas of concern. I know, Senator Westlin, you're going to continue to work on these issues. I'm happy to continue working with you on these. So as I say, I'm going to support moving the bill out of committee today so we can keep the process moving. And I look forward to having some conversations about this before we take it up on the floor.
Thank you. Mr. Chair.
Senator Westlin.
Thank you. Thank you, Senator Latz. And this was a situation where we ran out of a little bit of runway. And those were, in fact, the 2 issues that have been raised by the MACDL. And I know that my author and the other body is going to be meeting to try to work something out. And there was a discussion about what is that right number? Is it 7 to 14 days versus 28 days? And I think we are all amenable to that. We just ran out of a little bit of time. And also there are discussions about whether that should be a May. So just, I certainly will continue to keep you in the loop on those conversations as they're happening. And as I mentioned, there's likely to be some additional tweaks to the bill as those conversations continue. I do think this is very important work that we're doing. I think that this is really designed, as we've been discussing, to sort of address the situation where somebody's gone on arrival and they just wait it out. And what we do know is that once law enforcement becomes involved, an OFP has been filed, the police have been called, someone's released from custody, we know that those are the times that are the most dangerous for not always just women, but people who are victims of abuse. That is the most dangerous time often for people who are trying to break free from those relationships. So it's really just that balance of trying to make sure that we provide, adequate due process, but also make sure that we are dealing with an exigent circumstance where, as we've heard, the results of that oftentimes can have terrible, terrible results. So appreciate your thoughts, and we'll consider to work on this. And as I said, I know Representative Moeller is in the process of trying to set up a meeting with MACDL, and if I can be present at that as well, I will.
Mr. Chair?
Senator Latz.
Senator Westlin, I understand, if I remember right, there's a notice provision in the bill as well, so that the victim of the case would be notified when someone's being released. Is that, am I recalling that correctly?
Senator Westlin. Senator Westlin.
Maybe I'll phone my friend at council table and say, I'm trying to remember if we don't know.
Yeah, here, Mr. Chair, Senator Westlin, Section 8, which starts on page 7 of the A4, so that the protected party would get notice immediately after the entry of an order for release.
Right.
And that is, that's existing law.
Right.
There was a change in here, it might have to be addressed later, because after the issuance of a citation, the original bill didn't provide for the issuance of a citation. It would have been only a release, but now there are some circumstances under which it might be a citation, so maybe we could note that might be a correction that needs to be addressed.
I'll put a check mark
in the future. But that's also there for the intention of notifying the victims that, so they wouldn't be surprised by the release of someone. And I agree, that's very, very important that they be made aware of that as well. Thank you, Mr. Chair.
Any other discussion? Senator Holmstrom.
Thank you, Mr. Chair. Senator Westlin, so, I don't recall if there was a fiscal note last time this came to the committee.
I don't believe there is a fiscal
Mr. Turner?
note to this.
Fiscal note was not complete last time it came to the committee, but it is now. But the fiscal note isn't on the A4. The fiscal note has two costs, the task force, which is out, and then BCA reporting costs, which I think still remain in the bill.
Oh, actually,
Senator Westlin.
Mr. Chair, I thought we changed an effective date that took care of the BCA cost.
Mr. Chair?
Ms. Turner.
Yep.
Mr. Chairman, Senator Westlin, are you on line 3.20
Yes.
of the amendment? Is that?
That's
okay.
correct.
I didn't
Yes.
notice that.
Thank you.
Thank you.
You did magic.
Any other discussion? Senator Holmstrom.
Yes, thank you, Mr. Chair. So that's my question, is it's still requiring that the head of local law enforcement agencies collect this information and add to the reporting. And my concern is the staffing time it takes to do this, especially I think about Hennepin County, I think about Minneapolis, which is already painfully low on officers. And I'm not sure if this, I guess I don't know how robust this reporting requirement is going to look like on the ground. I wish there was somebody from an agency that might be able to give us an opinion on it. Have you had those conversations? Has there been any concern about the cost of implementing these reports?
Mr. Chair? No.
I'm sure if the agency feels like it's going to be a burden, they'll let us know. But oftentimes they can absorb the cost. But I'm not going to speak for them, but they'll let us know. Senator Holmstrom.
And again, Mr. Chair and Senator, so part of the groups that were consulted on this included law enforcement groups, and nobody had any issues with this. And I suspect this may be information that is available and it's just not being reported.
Any further discussion on Senate File 4301 as amended? Senator Holmstrom.
Thank you, Mr. Chair. One last question. Let's see, it's page 6, section 7, line 6.19. This is directing a judge when they are letting somebody out on bail that they shall make findings on the record. And one of the findings there to comment on is whether the respondent is in any pending petition for an order of protection or harassment restraining order, and if so, the nature of allegations in that petition. And my concern is that this could be somewhat broad because if they're in a pending petition, it doesn't mean it's been granted. There haven't been findings in that particular case, and it might be somewhat prejudicial for there to be an official finding that comments on that. I guess this isn't my area of expertise, though. So what is your response to that?
Mr. Chair, this has to do with pretrial release and whether they should be released, and these are just factors they're going to be considering. And so if they're going to be looking at these three things, and those three findings may warrant a pretrial release or not, but that's what that gets to. So it's really only about whether or not they should be released.
Senator Holmstrom.
Thank you, that's all.
Mr. Chairman.
Senator Pappas.
Mr. Chairman, I appreciate Senator Holmstrom's concern about the Minneapolis police officers. And Senator Holmstrom, I just want to assure you that they are, according to the research I just did, they're on track to reach their mandated 731 by 2027.
I don't know what that is.
Any further discussion? Senator Westlin? Any further comments?
No, Mr. Chair. I do, again, thank both the thoughtful discussion here in committee and also the thoughtful work that is taking place outside of committee. I will just say that you know, if anything, domestic abuse is probably underreported. And one of the reasons I think many people are afraid to make reports is the fear of being protected. And what we are trying to do today is making sure that we are closing some loopholes that will make it safer for victims of domestic abuse to report and to pursue charges and orders for protection. This is an important piece of legislation, and I appreciate the consideration of our committee, and I would appreciate a yes vote.
Hearing no further discussion, Senator Westlin moves Senate File 4301 as amended and proceed to the floor. All those in favor say aye.
Aye.
Opposed? The motion carries. Thank you, members. What's the next one? She's going to stay up here. So. Okay. We'll be moving to Senate File 4294. And I believe there is a delete everything amendment on that as well. As it's being passed out, Senator Westlin, could you give an introduction to the bill?
I can, Mr. Chair. I will just start off by saying that in 2023, 26 women in Minnesota were killed by a current or former partner, and of those, 15 of those deaths were from firearms. Currently, Minnesota's laws regarding mandatory relinquishing of firearms in orders for protection in domestic violence cases is disjointed, out of date, and lacks clarity. Senate File 4294 comes at the recommendation of victim advocacy groups like Violence Free Minnesota. It contains recommendations from the 2025 Legislative Task Force on Domestic Violence and Firearms, and it actually streamlines and clarifies and strengthens Minnesota's law to keep firearms out of the hands of individuals who should not have them. The structure of the bill, Mr. Chair, if we're looking at the delete everything amendment, there are various different parts of statute that have to be modified. And so Section 1 deals with child in need of protection or CHIPS cases. And the language there is adding that a petition, to the best of petitioner's knowledge, should include types and locations of firearms that are believed to be possessed by the abusing party, and that's related to CHIPS matters. If we go to page 3, page 4, page 5, that you will see a lot of language that has been stricken. Most of that language, Mr. Chair and members, is being relocated to one section, which is section 6. When we look at section 3, this is the section dealing with now orders for protection. That has, again, that same language as in the CHIPS section, that a petition for relief must describe to the best of the petitioner's knowledge the types and locations of firearms. However, it does say a court may not dismiss the petition if that information is not provided. As we move forward in the bill, again, we have language that is stricken, pages 9, 10, and 11, and those are relocated into a new section 6 that deals specifically with the transfer of firearms. I will note, however, that one of the pieces of this bill does include that a person is required not only to surrender their firearms, but they are also required to surrender permits to carry, and all firearms. I think there was some concern that it was only addressing handguns, but this covers all firearms. If you move to then section 6, Mr. Chair and members, this is the new section that focuses specifically on the transfer of firearms and locates this in one specific section. It includes requirements, including a deadline for compliance. It requires a hearing for the respondent to come in and testify as to whether the surrender of firearms has taken place. However, if it has, that court hearing can be waived. There are still 3 ways that someone may relinquish their firearms that is required to do so under CHIPS or orders for protection or other related orders. One would be through a third party, through a federal dealer or law enforcement agency. And again, it does require a deadline within 10 days for the person to relinquish their firearms. That is currently 3 days, so it is providing additional time to accommodate those who may have firearms in different locations, such as their cabins, etc. Excuse me. This does require courts to hold compliance hearings within 10 business days of issuing the transfer order. That hearing can be waived, as I mentioned earlier, if that subject of the order for protection or other order has complied. It does grant the subject immunity from criminal prosecution for complying with the order or providing testimony. So there may be an instance where doing so may have potential criminal implications. This bill provides them immunity and Fifth Amendment protections. If a subject chooses to transfer their firearms to a third party, they do now need to do that at a law enforcement agency supervised by an officer or under video surveillance that may be available in the parking lot of law enforcement agency. This does allow for law enforcement to dispose of permanently transferred firearms. It allows for law enforcement to consider a firearm abandoned if someone who temporarily transfers their firearm does not pay the fee required after 60 days. Requires a subject to submit a declaration of possession if they don't own firearms or possess them. And the subject is required to submit to all required proofs of transfer. However, those documents are confidential. Nothing in this bill prevents someone from also applying for an extreme risk protection order. So that is a fairly quick run through of the bill, Mr. Chair. And I will just say, in my experience as a family law attorney, one of the big challenges we face in orders for protection where someone is subject to a firearm restriction, there is currently no meaningful mechanism to ensure that that actually happens. There is a lack of clarity in the law as to what that includes. I had one case one time where the opposing party was the subject of an order for protection. They were not permitted to have firearms, but they went to Fleet Farm with one of the kids and purchased a bunch of ammunition. And when that was reported to the sheriff said, well, I can't do anything about that. We do know, Mr. Chair and members, that where there is domestic abuse present in a home, the presence of a firearm increases the likelihood of death for the victim of abuse by 5 times. 4.5 million women alive have been threatened with a gun by their intimate partner. 4.5 million women who live in the United States. Over the last 40 years, nearly 1 million women have been shot by an intimate partner. A 2017 study found that approximately 30% of intimate partner violence incidents involve a firearm. And when a homicide does occur as part of an intimate violence incident, a firearm is most often used. And I will say this too, we have also often heard the Violence Prevention Project has testified before this hearing and others in the past, and there is a correlation between domestic abuse and mass shootings. Oftentimes people who commit mass shootings have a history of domestic abuse. Multiple studies have found that laws that mandate firearm relinquishment in orders for protection and domestic violence cases are associated with a 10% reduction in intimate partner homicide. And lastly, I will say that in the Rahimi case recently before the Supreme Court by a vote of 8-1 determined that it was absolutely appropriate for state and federal governments to restrict or prohibit access to firearms by domestic abusers. This is a law that will save lives, and the current rubric that we have is simply not taking care of the problem. So that is the bill in a nutshell. Mr. Chair, my intention with this bill would be to pass this to the floor, but also would have this be considered for a potential omnibus bill as well, so dual track the bill.
Thank you, Senator Westlin. Just a note to the public, anyone who wants to follow this bill in its deleted amendment form, there's copies in the back on the back table. And my apologies for not making that announcement on previous bills.
And Mr. Chair, I believe they've also been posted. So,
all right.
So there has been notice of the amendments on these 2 bills.
Is there anyone willing to testify for or against this bill? Mr. Pallion?
Pallion, you got it.
Pallion.
All right. Thank you, Chair Limmer and members. I'm here from Violence Free Minnesota, the statewide coalition to end relationship abuse. We represent over 90 member programs who serve domestic and sexual violence victims in every county in Minnesota. And we're in strong support here of SF 4294. As Senator Westlin referenced earlier, we track every intimate partner homicide in the state of Minnesota. Many of you are surely familiar with the report we put out about that every year. In the years that we've been doing that, since 1989, consistently guns show up as the #1 leading cause of death for intimate partners in the state. Consistently, it's between 50 and 60% of our intimate partner homicides are done by guns. For comparison, the next highest instrumentality for killing is stabbing at 20%. These numbers actually get even more skewed if you isolate the data only to the bystanders and interveners who are killed incident to domestic violence. So you're thinking of the neighbors, the children, the friends, the family, the law enforcement, and other first responders who are killed in acts of domestic violence. Those numbers are actually more extreme for firearm homicide than intimate partners are. So it's about 75% of those people who are killed in those incidents are killed by a firearm. But firearms are not just a means of homicide. They're also an extremely potent tool of control for abusers. Survivors report to us all the time being threatened with firearms, having somebody kind of menacingly clean a gun while having an intense conversation, having somebody simply look at where the gun is stored in a moment of anger are all ways that survivors are having their compliance compelled by their abusers. And so survivors are all just intimately familiar with how dangerous a gun can be in their home and what that means for them and how they have to act around their abuser. Our legislature and legislatures around the country have recognized these power imbalances and these safety risks, and so all around the country there are laws banning people subject to these orders for protection, domestic abuse no contact orders, and child in need of protective service orders from owning firearms. But as the senator mentioned, there's not an official statutorily mandated process for taking these guns out of homes. This bill does a really good job of making sure that survivors know exactly what they can expect regarding firearms when they file for protection. They don't have to wonder if it's going to be the sheriff or the local police department. They don't have to wonder if someone's coming today or tomorrow. There's a process and they know what to expect out of it. This is going to help survivors know what to happen and maybe encourage them to do to file for these types of protective orders more often. And then when those orders are granted, we believe this will make them much more effective and will save some lives in Minnesota. Thank you.
Thank you.
Mr. Chair, I did.
Sarah Westlin.
I did neglect to mention, and it may or may not be important to some folks, but this is a bipartisan bill. In the other body, the chief author is Representative Scott, who has actually done a lot of work around domestic violence and is the chief author in the House. And I would certainly welcome any bipartisan authorship on my bill.
Thank you. Anyone else who wishes to give testimony regarding this bill? Come down to the testifying table.
Sorry,
Ms. Williams, welcome back.
Thank you.
Would you identify yourself for the record again?
Jana Williams, and thank you, Chair Limmer and members of the committee. I actually didn't prepare anything for this one, but this goes hand in hand with the domestic violence with Allison, because this case specifically with firearms hits home with Mariah Samuels. That was just killed September 14th. Her partner actually, 2 weeks prior to that, he was released. This man had been released, this David Wright, had been released from federal custody for sitting, multiple domestic abuse and other charges. He spent 15 years behind bars. And then 7 months, Mariah had dated this man. It was, I believe, August 30th, where he pistol whipped her. He was on federal parole, pistol whipped her, held the gun to her head, and strangled her, all on Ring camera. The police arrived. Again, he was GOA, gone on arrival. And she went and filed a few days later, because it was over the weekend, filed for an OFP. That OFP was served to a guy that was on federal parole. And where is the loophole? Where is the failing in this? Because instead of arresting him, they served the OFP. 2 weeks later, she called 911 September 14th at 3:30 a.m. when her abuser was threatening her life, telling her he was texting her saying that he was going to kill her, her children, and her father. She called 911. Minneapolis PD arrived at 3:30 in the morning. They did. They looked at her phone and said, just text messages, nothing we can do about this. He waited for her until 7:30 in the morning, and he shot her 22 times. There are loopholes that need major attention. And this is one of them. You know, there's got to be some sort of checks and balances for this. There has got to be. You know, this doesn't make sense to me. You know, I have tried to prevent this with Allison's murder, to try to prevent other domestic abuse survivors from suffering the same thing that Allison did, with the loopholes within law enforcement. I had no idea that this process would take this long. But I do appreciate you listening to this story, because these women, these victims are gone. They don't have a voice anymore. And so we've got to be their voice. And that means you too. Thank you.
Thank you, Ms. Williams. Any further discussion? Hearing none. All those in Senator Westlin moves that Senate File 4294 as amended be recommended to pass. Which way do you want it to go, Senator Westlin? To the Senate floor.
To the floor, please.
Okay. All those in favor say aye.
Aye.
Opposed? The motion passes. Thank you, Senator Westlin. Okay. Is he coming down? Oh. Senator Draheim, welcome to the Judiciary Committee. We've been waiting for you.
I know some have. Thank you, Chair. I do have an amendment too.
This is Senate File 3650.
Correct.
And as it's being passed out, Senator Draheim, you have an amendment. I haven't seen the amendment at my desk yet, so let's wait for it to be passed out.
And Chair Lemmer, I did share this with the committee ahead of time.
Senator Draheim.
It is really a short amendment. It's the 8-3.
Now, this, Senator Draheim, this is not the committee of original jurisdiction, so we will have to vote on the amendment. So if you'd like to start by explaining your bill and then explaining the amendment and how it fits in. Go ahead.
Thank you, Chair, and thank you, members. Senate File 3650 deals with prohibiting marketing on television of prescription drugs. We are one of 2 countries that allow advertising of prescription drugs on television. It's us and New Zealand. And when you look at the cost of care, our healthcare costs are approaching 20% of our GDP. We're talking trillions of dollars. Of those trillions, pharmaceutical is the largest piece, in my opinion, of that cost of care. And according to the FDA, the top 10 pharmaceutical companies spend about 25% of their expenses on marketing. The average TV viewer watches 9 drug advertisements a day when they're watching TV. 9 a day. That's 16 hours a year. And that is more time than they would spend with their doctors. The average person would spend with their doctors. There has been some debate that these TV advertisements are deceptive. They're misleading. They create consumer confusion. There's something called the picture superiority effect, where when you look at an advertisement for pharmaceuticals, bright colors, everything looks perfect, everybody's happy, etc. And I know we're not here to discuss that part of the why, but I do believe
if we can do this, we will help safeguard the public health, like we did with tobacco and alcohol and some adult content, and there are others. And in the meantime, we can save the state of Minnesota millions of dollars. So that's it in a nutshell, Chair.
Thank you, Senator Draheim. Did you want to have the amendment A3 be introduced at this time?
I would appreciate it, sir.
Yeah. Why don't you explain your amendment?
Okay, thank you. So the A3 amendment is really short. On line 8, we just insert, except the prescription drug only includes drugs covered by the Medical Assistance Program, Minnesota Care Program, or State Employee Group Insurance Program, or CGIP is what most of us refer to that. So it's the largest state programs that spend money on these pharmaceuticals.
Anyone in the audience who wishes to speak for or against the bill? Come on down.
Mr. Chairman,
Senator.
just wondering on the amendment, if we were going to vote on the amendment, I had a question about it.
That's okay. We'll act on the amendment now. Is there any discussion on the amendment?
Mr. Chairman, I'm just trying to understand, so that the effect of your bill with this amendment would be only those drugs would be banned from television that are covered by these programs. Am I correct on that?
Sir Draheim.
Sure, thank you. You're correct, Senator Pappas. That would be only those drugs. There's a little thing called the Constitution that I'm sure we're going to hear about here in a minute.
Well, we have constitutional experts on this panel, you know.
Yes, I know, quite a few.
Questionable
experts, yeah. Thank you, Senator Limmer. But Senator Pappas, that is why we are limiting what we're going to restrict the marketing, the TV advertisements to. So the TV is the open air TV, and now we're going to limit it a little bit more and just include those bigger programs where the state spends literally hundreds of millions of dollars on pharmaceuticals, hundreds and hundreds and hundreds of millions of dollars. So
okay,
I hope that
Mr. Chairman, I would move the A3 amendment.
Senator Pappas moves the A3 amendment. On the amendment, is there any further discussion? Hearing none, all those in favor say aye.
Aye.
Opposed? The amendment is adopted. Now we'll go to our testifier. Would you identify yourself for the record and then proceed with your testimony?
Absolutely. Good afternoon, Chairman and members of the committee. My name is Emily McGann, and I represent PhRMA. PhRMA represents the country's leading innovative biopharmaceutical research companies. I'm here in respectful opposition to Senate File 3650. This bill would prohibit drug manufacturers from advertising prescription drugs on TV and streaming services to Minnesotans. The bill's ban on advertising raises serious First Amendment concerns and is likely unconstitutional. The U.S. Supreme Court has developed nearly 4 decades of jurisprudence to prescribe efforts by the federal and state governments to regulate advertising of commercial speech, particularly where the regulation is content or speaker-based. And Senate File 3650 would likely fail to meet the test for restricting commercial speech laid out in those cases, including the case Central Hudson Gas Electric Corporation versus Public Service Commission. Additionally, the Supreme Court made clear in a 2011 case, Sorrell versus IMS Health, that, quote, speech in aid of pharmaceutical marketing is a form of expression protected by the free speech clause of the First Amendment, and where content-based is subject to heightened judicial scrutiny. Furthermore, because most advertising to consumers is conducted on a regional or national basis, the bill raises constitutional concerns because it would likely regulate advertising originating in a state other than Minnesota. For these reasons, we believe the bill is likely unconstitutional and respectfully oppose it. Thank you.
Thank you. Any questions for our testifier? I did not see anyone else coming to the table telling us they would want to testify on this bill. Any further discussion, Senator Holmstrom?
Thank you, Mr. Chair. Senator, you had said that you pushed the A3 specifically to skirt the confines of the First Amendment. So how exactly does this address those concerns that we just heard about?
Senator Draheim.
Thank you, Chair, and thank you, Senator, for the question. I think skirt's probably too strong a word, but I do appreciate that. The Central Hudson test, from my naive understanding of it, the primary goal is to have substantial interest for the government or the state in this case. And I think this amendment helps us down that pathway. So my understanding is you have to narrowly tailor it. And I think by limiting it to these couple Minnesota healthcare programs that spend, like I said, hundreds of millions of dollars, and limiting what kind of marketing or advertising. So it's just over the air, and the streaming is included if it's a kind of a broadcast that's over the air. So kind of public, your ABC, NBC, CBS, PBS, those type of channels. So it's just, we don't have cable TV anymore, and most people don't use rabbit ears, but it would be those type of programming that we would ban the marketing. So that is my attempt, and I know we do have some experts on the board, but I think we're getting there.
Sarah Holmstrom.
So my primary concern with this is not the intent, but rather the potential cost of litigation after the passing. If we're trying to save a few million, who knows what we're going to spend defending this or watching it burn. But I am not a constitutional expert. I believe that the resident constitutional expert on this board might have a question or two.
Senator Cruz.
Mr. Chair. Thank you, Mr. Chair, and I'm certainly not a constitutional expert, but scholar. Sorry. Well, definitely not a scholar. So we talked before, and you know I love you. It's just it seems pretty obviously unconstitutional to me, and it's because you got like two significant hurdles, maybe more. But the first is the First Amendment. And it is commercial speech, but commercial speech has been upheld as protected for many decades, and there's been many cases on that, including many, including pharmaceuticals. And they've generally, we can argue about whether they're misleading or not, but they've been generally upheld to be not misleading. And if they are, then there's ways to address that are more narrowly tailored than to just blanketly ban them from advertising on TV. So that, and I appreciate the amendment, but the amendment, I guess, maybe gets at the state interest. Is that kind of what you were thinking about your amendment, to kind of bolster the state's interest in regulating this? Was that what your amendment gets at?
Chair Draheim.
Thank you, Chair. Yes, that it was the intent.
Mr. Chair.
Senator Cruz.
Thank you, Mr. Chair, and thank you, Senator Draheim. I assume that's what the purpose of the amendment was, and it probably does strengthen the state's interest. Although I think the state has an interest, even if it applies to prescription drugs that are not exclusively, or that maybe the state doesn't use in their programs. I think the state has an interest in this at all. To me, this is. It's not narrowly tailored to just kind of have a blanket ban. I think that's already been tried and failed in court. But And then that's the first hurdle. And then the second hurdle is like federal preemption. The Food and Drug Administration regulates this, and there's something called, and I'm not familiar with this, but the Federal Food, Drug, and Cosmetic Act, and there's all of these federal laws that govern this, and when the state starts straying into this, I think we're going to be running afoul. And I've said this on other bills, and I would like to stay consistent, which is that the litigation on this is going to fly the second the governor signs this into law. The big winners of this are going to be the lawyers. Like, that much is for sure. And it's going to probably cost the state a lot of money, probably into the millions on this one. And in the end, I think we're probably going to lose, and then the taxpayer is going to end up footing the bill. So, love the intent. I appreciate you bringing it forward, but simply on constitutional grounds and protecting the taxpayer dollars in terms of what it's going to cost to defend this and what the state might be liable for in terms of attorney's fees, I can't support the bill.
Senator Draheim.
Thank you, Chair Limmer, and thank you, committee, for the discussion. My experience over the last 10 years has been anytime we try to negotiate with the pharmaceutical industry, they're going to sue us, even if they tell us they're not going to sue us. And we have to do something about the cost of care. And when you look at the aging population and these people on fixed incomes, everything that's going on with the gap coverage, I had two ideas what to do. One was this. The other was to mandate list prices on pharmaceutical advertisement. And I guess my question, where I'm going with this to our scholars on the committee, do you believe that would be constitutional to require a list price on the advertisement of pharmaceuticals?
Senator Kroon.
Thank you, Mr. Chair. Thank you, Senator Draheim. I honestly don't know the answer to that question. You can have people, I don't know. I've not researched it, not prepared to talk about that. So I'll give you the answer, maybe. But no, I appreciate it. And I'm not suggesting that anytime pharmaceuticals or any industry threatens to sue based on something we do here, that's a basis for not passing the law. Don't get me wrong. If I thought that their claims were weak, the fact that they might threaten suit is not a reason to not pass a law. I agree with you there. So that's not what I'm thinking. I'm thinking of the likelihood of success in their lawsuit, which I think is pretty high. Then that changes the calculation for me. But appreciate the conversation. Thanks.
Sir Latz.
Mr. Chairman, I just want to note that with all the disclaimers about constitutional expertise around here, someday if Senator Holmstrom serves long enough on this committee, he will achieve the vaunted status of the pseudo-JD Senator Limmer as constitutional expert on this committee. And when you leave us from this committee, Senator Limmer, we'll have some worthy successors.
Maybe. Senator Westlin, you've been waiting.
Thank you, Mr. Chair and members. So, a couple of things. Commercial speech is not afforded the same level of strict scrutiny that other types of speech are, and there's an intermediate test. And what the first part of that is the speech truthful and not misleading. And I think when we look at some of these advertisements who are generated specifically to sell a product, are they making claims that might tend to mislead? And I think that there's certainly an argument to be made in some cases. Part two of the test is the government interest substantial. And I think when people are using Dr. Google and advertisements on TV to figure out what their health problems are and then try to advocate to receive a drug that maybe they haven't been screened to receive, I think our government interest in ensuring that people are actually seeking medical care and advice is certainly a substantial government interest. Does the regulation directly advance that interest? I would argue that it does. And then lastly, is it narrowly tailored? Is it a reasonable fit for what we're trying to do? So I do think that when we are, I'm pretty sure I see more than 9 pharmaceutical ads in one TV sitting. And, it's all these promises about, if you're having this symptom, maybe this is the thing that you need and this is going to make your life better. I do have concerns that people are diagnosing their health issues based on a commercial rather than seeking medical care. And I will say this too, sometimes, our job is to pass laws, and it is true that we shouldn't intentionally pass laws that we think are just obviously on their face unconstitutional, but we also know that sometimes the way law develops is by precedent, and that happens by lawsuits. Something happens, a lawsuit is brought, and the courts are going to determine the outlines and the parameters of what passes constitutional muster and what doesn't. And while, that's always a bit of a crapshoot, but I do think that I will support this bill, and if it does result in a lawsuit, that may be an important leading edge of consumer protection when it comes to pharmaceutical ads, but also when we look at the costs of pharmaceuticals for people who need them. So I appreciate you bringing this bill, and I would like to add myself to the pantheon of constitutional experts. I'd like a motion for that.
Thank you, Mr. Chair.
Senator Cruz.
I'll make that motion. No, I'm kidding. You'd be on the list by yourself if it passed, because I'm not a constitutional expert. But I agree that if misleading or untruthful advertising is not protected, I agree with that. But I think that's normally, and maybe we can have a pharmaceutical person confirm this, but my understanding is that would be on a case-by-case basis. So if a regulatory agency said you can't keep this advertisement up because it's untruthful, you're making claims that can't be backed up by scientific evidence, and then that wouldn't be protected. But to say that no pharmaceuticals can advertise on TV is not narrowly tailored to that, that one instance, or those, some instances, I don't know how many, where there isn't, maybe they aren't truthful. This is kind of a shotgun approach that scatters the whole landscape and prohibits it. And so we need to get it more narrowly tailored. So, but I don't understand why there's so many pharmaceutical commercials either. I don't understand that world, and that's not really where my focus is on. I just would want to see the bill get a little more focused and narrowly tailored before I could get interested and get on board with the merits of the bill. Thank you.
Mr. Chairman.
Sarah Pappas.
I know why there's so many commercials on, because they work. Because the consumer goes to their doctor and says, hey, I heard about this new drug, and the doctor prescribes it, and the pharmaceutical company makes more money. So, it must be useful for them. If they're spending so much money on marketing, they must make a profit over and above that. So, it works.
Senator Draheim, I have a question. Even if this went into law, is there any guarantee that the costs that would go into advertising would be erased from the final product cost, and that those savings would go on to the consumer? Or would that difference just simply be added to the profit margin of the pharmaceutical company?
Thank you, Chair, and a great question. And being a business guy, that I know if you spend 25% of your budget on marketing, you're doing more marketing than just TV advertisement. There's handouts, there's pens, and all the other stuff they do, and staff. And then, of course, when you look at all 50 states, would we see a noticeable difference? I don't know. So there's no guarantee that it would. But I think more importantly, it would send a message to the pharmaceutical industry that I think there is a problem with society seeing 16 hours of pharmaceutical ads in a year. And when we look at different segments of our population, there are some people that are prone to suggestion. And if they continually see commercials on TV, they convince themselves that there's something wrong with them. And then they go into the doctor or the emergency room. So I think there's a lot of different issues here at play, and I just want to put a plug in for William and Mary Law Review. They had a nice little article on a lot of the issues that are being discussed here. Came out in 23. Obviously, I'm not a lawyer. I didn't probably communicate as well as I should have on what Senator Westlin talked about on that constitutionality piece. That's why I'm glad I never served on this committee. No offense, Chair Latz. You guys do the great work. You're the hardest working committee. I do believe that, and that's why you're here on a Friday, right before break. So, but I don't know if I answered your question or not.
We're here because Senator Latz wants us here. You're welcome. Yeah. Thank you, Senator Draheim. Is there any further discussion? Senator Draheim, I have a question. Do you want this to go to the floor, or do you want this to be laid over for an inclusion in, I believe, the Commerce Bill?
That would, I would think that Senator Latz would probably like it to go to Commerce than the floor, and they can decide what, that's the Committee of Origin, I believe, and and then they can decide what to do with it. Being in the minority, I don't feel I can, I would love to go over to the floor, but I think it should go to Commerce personally. And I just want to thank my co-authors, Senator Rasmusson and Maye Quade, on this bill too. So, and I'm hoping one of you scholars on this committee, if this does not pass the finish line this year, takes it up next year and continues the effort for it. So thank you.
Senator Draheim, I got a late notice that said that Commerce wants it.
Yeah.
So, Senator Pruitt.
Thank you, Mr. Chair. And Senator Draheim, I'll certainly read that law review article. I'm not a constitutional law expert. And so happy to look into this more and see if there's some way to narrowly tailor this a little bit more. And Mr. Chair, if Senator Draheim keeps on saying nice things about us, maybe we'll all end up supporting the bill after all. I don't know.
All right. Senate File 3650 as amended is before us. Senator Clark moves Senate File 3650 as amended be recommended pass and re-referred to the Commerce Committee.
Thank you.
Thank you, Senator Draheim. Oh, we forgot to vote. I am out of practice. Let's back up. Senator Clark moves that Senate File 3650 be recommended to pass as amended. All those in favor say yes. Aye. And opposed? The motion carries. Thank you, Senator Draheim.
Thank
it's
you,
official now. What's next? We'll stand in recess for 2 to 3 minutes to get some paperwork.
Senate Judiciary Committee is back in order. Senate File 2233, Senator Gustafson. And Alexi Stephanie will be our testifier. Come on down if you have a seat next to Senator Gustafson.
Thank you, Chair Latz and committee members. SF 2233 establishes a task force to design a yellow alert system which would be used to enlist public assistance in locating vehicles that flee the scene of a hit and run that results in the injury or death of another person. Hit and runs are a persistent and serious issue, and they account for a notable share of all traffic fatalities. The first few hours after a crash are critical, and a public alert system would help law enforcement act faster. And with your permission, I can turn it over to our testifier now.
Ms. Stephanie, go ahead and introduce yourself.
Good afternoon, members of the committee. My name is Alexi Stefani, and I'm a hit and run. No, you're good. And I'm a hit and run constituent. The implementation of yellow alerts in Minnesota is very important to me, and it would greatly benefit our community. Oftentimes, we don't realize how serious something is until it happens to us. On the run from law enforcement, a driver ran a neighborhood stop sign and collided with my vehicle's driver's side at approximately 65 miles per hour in a 25 mile per hour zone. My car then hit a concrete streetlight, a stop sign, and went through a yard, and finally collided with a house. Although a demolished car remained next to mine, no driver could be accurately identified for prosecution. After reading my no prosecution letter, I knew I wanted to dedicate my life to improving my community. I enrolled in law school and I will graduate this spring. I published in the Star Tribune about the importance of yellow alerts and reached out to others who have helped me bring this idea in front of you today. Because of the accident, I missed a month of school and months of college athletics. The fear I had to overcome just to enter a vehicle or attend appointments is something that I can't forget. Giving up my senior season of college soccer because of my head injury is something my younger self would never have imagined. Returning to campus, I struggled to find my classrooms and to remember my professors' names, all while the driver at fault walked free. There needs to be a change, and a yellow alert system is the first step in the right direction and should be implemented in Minnesota. It wasn't the shattered window, the cuts, or the bone bruises that hurt me the most. It was a lack of justice that cut far deeper. My father raised me to understand that life is not about what happens to you, but how you react to those things. Well, Dad, this is my reaction. Thank you so much for your time and for the responsibility that you carry in protecting our community.
Thank you, Ms. Stefani. I'm sure your father will be very proud.
Thank you.
Senator Gustafson.
Thank you, Chair Latz. And I should have mentioned, with apology, Senator Cruen is a co-author, and actually our testifier, Alexi, is his constituent. So just wanted to recognize that.
Gotcha. All right. Any questions or discussion members have on this proposal? Not seeing any. Mr. Backus, got some dates to correct here?
Mr. Chair, yes. On page 2, line 17, and page 2, line 23, delete 2025 and insert 2026. On page 3, line 18, do the same, delete 2026 and insert 2027. I'm sorry, it's not the same, but it's the same concept. And then 3.26, delete 2026 and insert 2027.
All right, Senator Cruen moves adoption of that amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion? Not seeing any. Senator Cruen moves that Senate File 2233 as amended be recommended to pass and be re-referred to the Senate Committee on State and Local Government. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Gustafson. We have another one for you, Senator Gustafson. Senate File 4735.
Thank you, Chair Latz and committee members. SF 4735 addresses a serious public safety concern: adults who deceive minors about their age in order to commit crimes, by adding intentional age deception as a recognized aggravating factor in criminal sentencing. This bill allows the judge to consider age deception as a relevant factor when determining the appropriate sentence for a crime. When an adult pretends to be a minor to gain a child's trust and facilitate a crime, it reflects a heightened aspect of manipulation and premeditation involved in these offenses, and the bill recognizes that. And I'd also like to thank, again, more Anoka County representation. Senator Cruin is on this bill, and Senator Housley as well. Thank you.
Do you have any testifiers, Senator Gustafson?
No, Chair, I do not.
All right. Anyone in the room here to testify on this bill? Not seeing anyone. Any discussion by members of the committee? The intention is to move this bill on to the Senate floor. Senator Holmstrom.
Thank you, Mr. Chair. Senator Gustafson, what types of situations would these pertain to?
Senator Gustafson.
Thank you, Chair Latz, and thank you, Senator Holmstrom. For example, if somebody who was, say, 21 years old and decided to pretend to be a younger age to enroll in a high school, for example, that would be, if that were to be found out and a crime was committed, or just, the deception piece of it, the judge would be able to take in that deception as part of their aggravating factor.
Senator Holmstrom.
Thank you. That's clarifying. I think Disney's going to have a problem with this bill. Sounds like a bad movie, but I'm game.
I don't know what Disney movies you're watching, but thank you.
That'll teach you. Any further discussion? All right, Senator Cruin moves that Senate File 4735 be recommended to pass and be re-referred to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. All right, thank you, Senator Gustafson. Okay. Sure. Senator Pappas, would you take the gavel?
I have to fill in Senator Limmer's and Senator Latz's shoes here. Senator Latz, Senate File 4760.
Madam Chair and members, this Senate file is the department's policy bill, and I think everything that's in there, Department of Public Safety, everything that's in there has already been heard individually by this committee along the way here. But there are a couple of amendments, including delete everything to get things started. So 4760 itself was basically, will become the vehicle bill for the Department of Public Safety's policy bill.
Senator Latz, did you want to add the amendments now?
We can, let's see, they are drafted to the delete everything amendment, so
Yep.
Yes, let's do that. So the A1 amendment is the delete everything amendment. I'll move adoption of the A2, which council can correct me, I think it's just a technical amendment.
Okay, technical amendment.
Yes.
Do you want to add the A3 as well, or just go with the A2?
Well, I'm going to want to do both. You tell me what order to go in. They're both drafted to the delete everything amendment, the A1. So I'll move adoption of the A2 to the A1 for starters.
Senator Latz moves adoption of the A2 amendment to the A1 delete all. Are there any questions? All those in favor say aye. Aye. Opposed, nay. Motion prevails.
And Madam Chair, the A3 amendment is a little bit of cleanup left over from the TWI reform bill that we passed last year. Part of the reforms last year extended the length of the temporary licenses following a DWI incident which revoked a license from 7 days to 14 days. But in the course of that, and we did it for all of the temporary licenses that are issued following a DWI incident, but we didn't quite catch the test refusal provisions under 171.177 subdivision 8. So this would change that temporary license from 7 days to 14 days.
Senator Latz moves the A3 amendment. Are there any questions? All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. Senator Latz on the delete all A1 as amended.
I move adoption of the A1 amendment.
Are we ready to just adopt the delete all? Any questions?
This is in the nature of an author's.
And then you'll explain, go through exactly what's in it?
Well, the department, I think, will.
Department will.
Yeah.
Okay. Then, can we adopt this? Yeah. Okay. All in favor of the delete all amendment, and then we'll have department go through the bill. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. A1 amendment is adopted. You have someone here from Public Safety?
I would assume there's a whole row of agency staff around here somewhere.
Yeah. There's Mr. Anderson from MMB. Who else is here? Ms. Gallagher from DPS.
Yeah, just
Okay, so she's going first. This is Ms. Gallagher. Okay. Ms. Gallagher, welcome to the committee.
Thank you. My name is Megan Gallagher. I'm the Legislative Director at the Department of Public Safety. There's a couple of our policy bills included in this DE amendment. The first relates to driver and vehicle services. It's a bill that was heard in your committee earlier this last week, I believe, and then also in transportation. It cleans up a couple of things from the ignition interlock bill that Senator Latz referenced from last session, and it also creates some data protections for the credential indicators that are on driver's licenses and IDs, such as the mental health indicator and the autism indicator. There's also a bill in here from our Office of Justice Programs, which were authored by Senator Oumou Verbeten. Both of those bills relate to both crime victim rights as well as data protections for our missing and murdered Indigenous offices and research data that is collected by the Office of Justice Programs. There's also a technical bill from the BCA included in this bill that makes some changes and corrections to a reimbursement provision related to local law enforcement where they're, for their investigations. Sometimes they have investigations that are unexpected and take longer and cost more. We have a provision to provide reimbursement to them for those types of investigations, and then a couple of other cleanup items from the BCA just to clarify some language that to fit with how things are currently operating, update some outdated language. Those are the pieces that are currently included from DPS.
Okay. Any questions about the Department of Public Safety provisions? That's Article 1.
I believe there's a couple of articles from Public Safety. Article 1, also Article 2 and 3.
Okay. All right. Thank you. No questions? Then who's next? Article 4? Just go through the articles. And would you introduce yourself for the committee and the tape?
Yes, thank you. Chair and members, my name is Kelly Haff. I am the Legislative Director for the Department of Corrections. Article 5 in the bill is the Senate File 4370, authored by Senator Clark, that you heard last week. This is our standardizing licensing facilities proposal to take the licensing from adult facilities and that structure and apply it to juvenile facilities as well as halfway houses. And Article 6 is our technical omnibus bill, which you heard on Wednesday night, Senate File 4293, authored by Senator Westlin. It updates statute to reflect current substance use disorder practices in the Department of Corrections, as well as expands the DOC's use of mental health unit beds in our facilities.
Okay. And Article 4 or MMB? Okay. Mr. Anderson?
Thank you, Madam Chair and committee members. I'm Eric Anderson, Director of Government Relations at Minnesota Management and Budget, and I would speak to Article 8 in the DE. This is also the underlying bill that makes edits to the Criminal Offender Rehabilitation Act, which was passed into law in 1974 to encourage and contribute to the rehabilitation of criminal offenders. The law establishes that public employers cannot disqualify an applicant solely based on a criminal conviction. And as the law had been understood until recently, there was some discretion allowed for public employers to disqualify an applicant if their conviction was directly related to the employment sought and there was not sufficient evidence of rehabilitation and present fitness for the position. This had been upended in a recent appeals court position, McNitt versus Minute, that had interpreted the law to mean that if an applicant can produce certain documents outlined in the statute, they are considered rehabilitated, and the public employer does not have any discretion to disqualify an applicant whose conviction directly relates to the position. And in this case, an applicant was disqualified by Minute for an IT position within the Department of Education after a criminal background check showed a conviction for possession of child pornography. And the Court of Appeals held that once the applicant provides the documentation listed in the statute, such as a state or federal discharge order, the applicant has satisfied the statutorily defined means of demonstrating rehabilitation and cannot be disqualified from employment. And so this decision fully removes employers' reasonable discretion to consider the facts and seriousness of the crimes committed and how they relate specifically to the employment sought. And we feel it's reasonable in this example that someone has been convicted of possession of child pornography and is seeking a job with access to data systems containing information about children, that a more nuanced consideration of rehabilitation and present fitness should be allowed rather than simple production of a discharge order. Public employers are the stewards of trust and welfare of Minnesotans, and we feel restoring the reasonable discretion serves in the public interest. And so we're just seeking to restore that previously understood level of discretion.
And Senator Latz, this is the first time the committee has heard this article, correct?
I believe that's correct.
That's correct. So maybe take a little bit more time. Are there any questions on Article 8? It's on page 61 for Mr. Anderson or for Senator Latz. Senator Kroon.
Thank you, Madam Chair. On the underlying bill 4760, so if I'm just understanding your testimony correctly, this would essentially legislatively overturn the Court of Appeals decision and reinstall some discretion back to the agency, which had been the practice prior to the Court of Appeals decision. Is that correct?
Mr. Anderson.
Thank you, Madam Chair. That is correct.
And Senator Latz, did you want to also comment? Okay. Okay. Then are we missing, thank you very much, Mr. Anderson. And then did we hear, I don't know, Article 3? Did I miss one? Anybody else coming forward to testify? So Senator Latz, we've heard just a brief summary of all the articles. I thought there was a DLC article. They did it. Okay.
I think everything's been covered.
All right, great. Then on the underlying bill then and the, any questions from any of the members? Senator Limmer.
Thank you, Madam Chair. First on the delete everything, page 55, could perhaps counsel explain the repealer on line 20, page 55, line 20?
The repealer?
Yeah.
Okay. Mr. Backus?
Madam Chair, members, this article came from Senator Clark's bill, Senate File 4370. It has to do with Department of Corrections licensing, so I would defer to the Department of Corrections to give the specifics on what's being repealed and why.
And Ms. Half.
Thank you, Chair and members. These repealers are either repealing sections of statute in 241.021, which is the big licensing statute, that are elsewhere in statute, or that have been relocated and rewritten in the bill.
Thank
Madam Chair.
Senator Limmer.
Also, on page 63 of the delete everything amendment, we're adding new classifications of employees or departments for the protections for judicial officials. We're adding department areas.
Senator Latz, did we have someone address Article 9?
Perhaps we did miss that one, but Senator Limmer has identified correctly. There are some judicial staff within the agencies that were not covered by protections for judicial officials, so this makes sure that they are included.
The question I had specifically was, I've been talking with our financial researcher. He claims that there's no cost to this, but I do know that the program is costly, and was wondering how we justify a zero cost line by adding employees to this.
Senator.
I'll ask Mr. Turner perhaps can address
Senator
that.
Limmer, I have some information on this from staff. This was Senator Champion's bill, Senate File 3665. It was sent for a fiscal note, and Mr. Turner can confirm that it came back zero, and I should turn it over to Mr. Turner.
Madam Chair, that's all I have to say. The fiscal note came back zero. I had the same suspicions when the bill came out as Senator Limmer, and I sent off the note, and there's no cost.
Okay.
Madam Chair.
Senator Latz.
I suspect there are just not that many individuals that are additionally covered, so the cost would be de minimis.
I remember,
Senator
Madam Chair, Senator Latz and I over the recent years have worked kind of in a tag team fashion regarding the establishment of protections for judicial officials and others. And we're always concerned about the Me Too factor from this point forward, that there'll be others that'll always be tempted to demand that they be added to this type of protection. But when we first got into this, we began to realize that it was somewhat costly, but at the same time, we rely on fiscal notes, but nevertheless, I suspect it'll cost something in the future as we continue to consider adding more and more employees to this.
Senator Latz.
Madam Chair, these employees that are added in this bill are basically those that act in the way of decision makers that could generate a grievance from the party that loses on the decision. So they'll, more than perhaps other employees, they need the protection.
Madam Chair?
Senator Limmer.
As I go into the retirement mist this year, I would only advise caution on adding more people unless there's plenty of money to handle it.
Senator Limmer, it's not clear to me that this is personal protection. Is it more just their data is protected, perhaps?
Madam Chair, it's data, it's public records, could be property records as well. The real problem is sometimes property records are not all filed in a digital format, and sometimes it can take a lot of man hours to find it and then cover it.
Okay. And Senator Kroon.
Thank you, Madam Chair. I think what's going on is it's because on page 64 they're excluded from the real property part of this, which is probably why there's no cost on the fiscal note, because we're just adding on to the take down their name, the part, which is far less costly than the real estate part.
Any other comments? Then Senator Latz for a motion.
To the floor?
Yep.
Madam Chair, I move that Senate File 4760 as amended be recommended to pass and be referred to the Senate floor.
Senator Latz moves that Senate File 4760 as amended be recommended to pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Opposed, nay. Motion prevails. Do we have another Latz bill?
I'll defer to Ms.
Okay.
Kaplan as to what we do next.
Okay. We're just waiting for copies of an amendment. And Senator Latz, is it 4703?
Yes.
Okay. Oh, we're going to switch to Claire's? Okay, Senator Latz, we don't have copies of your bill yet, so we're going to take up Senator Oumou Verbeten's bill. Do you want to come back and chair your committee?
Sure.
Okay.
Senator Oumou Verbeten, Senate File 4691. This is the first committee stop, and there is an amendment, the A4, in members' packets. That would be an author's amendment. Senator Oumou Verbeten moves adoption of the A4 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Oumou Verbeten, to your bill.
Thank you, Mr. Chair. This is the Direct Care and Treatment Agency bill. DCT is a highly specialized behavioral health care system. The state-operated system serves more than 12,000 patients and clients each year whose mental illnesses, behavioral disorders, and intellectual disabilities are so complex and challenging that other healthcare systems cannot or will not serve them. Most DCT clients and patients are civilly committed. This bill contains policy changes that address the following. First, ensuring that DCT can respond to Minnesota Sex Offender Program, or MSOP, data challenges in a reasonable time frame by allowing for responses from a second delegee. The current high volume of requests, which is up to over 3,000 per year, is making it challenging for one data practices compliance official to review data and respond to the requests in a timely manner. The second change is supporting standard healthcare operations by clarifying DCT's ability to share limited patient data in narrow and specific circumstances with regulatory and accreditation bodies and oversight agencies. So a little bit more about this. Because DCT patients are often unable to sign releases of information and lack a guardian or other representative, DCT is unable to share that necessary health information. Recent changes to Minnesota state law means DCT is unable to rely on HIPAA authorizations to complete a variety of activities that are central to the operation of the state-run behavioral health care system. Without authority to share health information in certain circumstances, DCT clients and staff are at risk of harm, and DCT faces increased regulatory risk. DCT faces risks with the current limitations in a few specific areas. Regulatory and accreditation bodies, they could be at risk of losing licenses, certifications, and accreditations. And if those were to occur, DCT would need to curtail services at this time when psychiatric and behavioral health beds are in very high demand. And then the wait list for DCT beds would also increase. More individuals with acute psychiatric conditions could remain in hospital or jail settings. DCT would serve fewer individuals that cannot be treated by community providers. And then DCT would not be able to bill insurance, Medicare, and Medicaid, which would ultimately impact our general fund. And then the second piece there is health oversight agencies. And so currently DCT cannot share protected health information with health oversight agencies without a court order. Lastly, this bill will give DCT the authority to share limited data with guardianship courts. When counties seek guardians for civilly committed individuals, the guardianship court will usually ask for physician statements and health information along with the petition. DCT must obtain consent from individuals to share their data and health information. The bill will still requires DCT to obtain consent to share data, except when a client lacks capacity to consent and or has a current legal guardian who is unavailable, is non-responsive, or refuses to authorize the disclosure. An individual who requires guardianship usually lacks the capacity to sign ROIs. DCT has many patients in its facilities that need a guardian, and the inability for DCT to share limited patient information to the court slows down the guardianship process, and this delays necessary health care and legal decisions for the patient. In some cases, the health of the client continues to decompensate because there is no guardian in place to consent to the treatment, and the DCT medical director cannot intervene until there is an emergency. So a lot there. DCT has vetted these provisions with external partners and other state agencies, such as the Ombudsman's Office, to ensure that safeguards are in place for sharing of data and authorization of medical care. You know, they've also been consulting with the Minnesota Disability Law Center. And I also have staff here from DCT to respond to any questions.
We have Dale Klitsky with us, DCT General Counsel. Do you have anything to add or just want to answer questions?
Chair, Dale Klitsky, General Counsel for DCT, no, unless you have questions.
Thank you. Any questions from members of the committee? Senator Holmstrom.
Thank you, Mr. Chair. Senator, on page 1 of the A4, subdivision 14, section B, it seems like we're trying to exclude sharing information with law enforcement. I think that this was addressed and amended in Human Services Committee, where they removed these lines 1.26 through 1.29, and I think DCT had said that that was something they were okay with. Would you be amicable to an amendment to do that same thing here?
Mr. Chair? Yes, we were in the process of putting this amendment together to make sure everything that was under Judiciary's jurisdiction was in there, but it's not needed. We can remove it.
Senator Holmstrom.
Thank you, Mr. Chair. I would move that we strike lines 1.26 through 1.29 of the A4 amendment.
Senator Oumou Verbeten, confirming your position on the amendment.
I'm fine with the amendment.
Any discussion? Seeing none. All those in favor say aye. 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 Opposed? Motion prevails. The amendment is adopted. Any further discussion? Not seeing any. My understanding is we are laying this over. So this is a clone provision. So the language changes will end up going to the relevant staff for incorporation in a different place. There being no further discussion, Senate File 4691 is laid over.
All right, Senator Latz, we have Senate File 4703 before us.
Thank you, Madam Chair and members. I do have an A4 delete everything amendment to offer, and I move it.
Thank you, Senator Latz. This is an author's amendment.
That's correct.
Senator Latz moves. Oh, okay. I'll give everyone a moment just to get the amendment passed out. Earlier, it was Senator Latz and I who were the only two who didn't have the bill. And then at this time, we were the only two who did have it. So Senator Latz moves the A4 author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails and the amendment is adopted. To Senate File 4703 as amended. Senator Latz.
Thank you, Madam Chair and members. This is an update to the extreme risk protection orders language that we've passed before. This is different updates than Senator Westlin had brought before us. So this provision is based upon input from a variety of stakeholders, including one prosecutor in particular who gathered information from others around the state who had experience in handling these petitions and orders at the district court level. So I'll just walk you through the provisions here. I'm working off of the A4 amendment now. The first provision in Section 1, you'll see it strikes the definition of family or household members that's in current law, and basically, and it does then adopt the definition already contained in 518B.01 subdivision 2 paragraph B. What that means is that there's a slightly expanded category of persons considered family or household members who could bring a petition or file a petition in court. There are basically two categories of persons that can do that. Family or household members, mental health professionals, three categories, and law enforcement. So the expansion here, if you look on line 1.9, parents and children of the respondent is expanded to include blood relatives. If you want to compare Chapter 518B against this, that would be your reference point. That's what I did just to make sure we had all the details accurate here. The other expansion on lines 1.12 to 14, it's that existing language out of 518B plus parties that have a child together or in which one of the parties is pregnant. And then on line 1.10, not only presently residing, but now includes those who have in the past resided with the respondent. Section 2 expands or clarifies those who may bring those petitions in court. So instead of just identifying the chief law enforcement officer or their designee, it covers the entire agency. Similar with the prosecuting agency's city or county attorney's office, so it doesn't have to be the county attorney as the named petitioner. And then it adds a provision that allows the respondent to petition on their own behalf. If you turn to page 2, there's just some clarification down at lines 27 to 29, 28 to 29, that these proceedings are in addition to some existing law, but does not restrict or limit law enforcement agencies' legal authority to respond to exigent circumstances. On page 3, the new paragraph N, this would require a judge to consider a petition for relief under this section when presented to the judge by the chief law enforcement officer or the chief's designee. The reason this has come up is because of the experience in some cases when the petition was presented for an emergency red flag order, and the judges not every judge was hearing those emergency petitions right away. They would wait until the next business day, or if it happened on a weekend, until Monday morning, which kind of defeats the purpose of an emergency ex parte order. And this aligns it with the same process for an order for protection that is in a separate statute. Section 3, the next paragraph there, basically clarifies that the communication of risk could be to not just the sheriff, but any law enforcement agency with primary jurisdiction over where the client resides. Client referring to client of mental health professionals who have that duty to warn. The next provision under Section 4 addresses service of the order itself, and basically it's mostly just a rewriting and clarification of the order to reflect the broader nature of the petitioner's city or county attorney's office, making clear who's responsible for the service of the extreme risk protection order when one is issued by the court. The paragraph D on line 4.17 changes the process, or the timing, I should say, for personal notice of personal service of notice for the hearing upon the respondent. So this would fill a gap because the original provision required that service be served at least 48 hours prior to the time set for the hearing. So this eliminates that 48-hour gap in there, allows service at any time before the hearing, but it still maintains the provision that the respondent may request a continuance of up to 14 days, and continues that the continuance shall be granted unless there are compelling reasons not to do so. So as a practical matter, the respondent would still have, under most circumstances, be entitled up to 14-day continuance if they're served less than 5 days prior to the hearing, so they have adequate time to prepare. And this is in those cases where it's not an ex parte emergency order, but rather it's the more standard timeline order for a red flag order. On page 5, paragraph G is new. There provides for service to be completed electronically or by first-class mail when an order is issued. Paragraph or subdivision 2 there regarding relief from the court, it adds in the harassment restraining order law. Section 9, I believe it's 69.748. I didn't confirm that. Maybe counsel confirmed. My memory is that that's the HRO law. If you look at line 5.26, it provides the relief by the court shall consider not just whether there's a conviction for cruelty to animals, but also a history of cruelty to animals. And then line 5.29 again adds in the HRO statute there for a factor for the judge to consider. You go to page 6, when the court is determining line 6.10 is just some clarifying language. Line 6.14 and 15 provides for when orders are subject to renewal or extension unless the original period, or unless a period longer than 1 year is agreed upon by the respondent. If they're not agreed upon the respondent, then they are subject to renewal or extension under the process that's specified in 624.7173. The next changes, 6.20 and 21, are basically clarifying language. And so is the change in paragraph G. The next provision does provide for sealing of records, and this does not give, this deletes that sealing provision. This is a fairly significant change in that it would then provide for all of the court records to be public, and that is was a pretty important provision in terms of transparency for the basis for issuing extreme risk protection orders and for analysis by those who are trying to determine under what circumstances the orders are being issued and whether the process is working as intended. The next page, line 7.1 and .2, provides for the consideration of whether a guardian ad litem should be appointed. So that's upon the request of either party to the proceedings. The next section 5 addresses extensions of the red flag order. It requires the court, again defined by clear and convincing evidence, whether or not the respondent still poses a significant danger of bodily harm to other persons or is a significant risk of suicide by possessing a firearm, and then provides for an extension up to 5 years if the court makes those appropriate findings, and if there's been a prior violation of a red flag order on 2 or more occasions, or the respondent has been or subject to 2 or more red flag orders. So basically, failure to follow the extreme risk protection order would or could result in a lengthier extension of the order's period of time, up to 5 years. The language in the next paragraph C is mostly clarifying and gives the court's guidance on when to deny the request, and then again clarifies the language at 6 months. So most of that is just technical clarifying language. If we go on to the emergency issuance of the extreme risk protection order, section 6, which is the next page, page 8, I'll direct your attention down to lines 8.15 and 16. It's mostly clarifying language there. Lines 26 and 27 clarify that the respondent has the right to request a hearing within 5 days of the service of the emergency order, and that the order, when served, must include clear or conspicuous notice that the respondent has the right to make that request within 5 days of the service of the order. The next page, section 7, gets into the transfer of firearms. And right now, the language in the statute provides that the transfer must occur within 24 hours or as soon as reasonably practicable. But when this adds the ability of the peace officer to collect the firearms immediately under certain circumstances when there's a search warrant issued pursuant to paragraph D. That way there is not a gap between the time the order is issued and when the firearms must be turned over. It's better for public safety purposes. It also would save law enforcement potentially another trip to the respondent's residence or location to obtain the firearms. Lines 23 and 20 to 25 delete the provision that law enforcement must compensate the respondent at fair market value and may not charge the respondent any other processing fees. This was a concern of law enforcement agencies where, frankly, there were some cases where they were confiscating a large cache of firearms, and it was a large fiscal burden on the agency to compensate at fair market value. I believe if there are any other questions about that provision, it's my hope that we have some representatives from the chiefs of the sheriffs here that would be in a position to explain that a little bit more, since they're the ones that made that request. Line 31 on that page clarifies where the proof of transfer must be filed. Actually, the whole rest of that paragraph indicates that all of the filing should be done with the court rather than with the law enforcement agency. And then line 18 of page 10, rather than sealing the affidavits and proofs and so on, provides the court shall make them confidential. The following paragraph, where the changes that are made, again, the respondent or the law enforcement agency can take possession of everything as soon as practicable. It also adds a provision on line 31 that if the respondent voluntarily complies by surrendering the firearms prior to the execution of a search warrant, the respondent then becomes immune from criminal prosecution for unlawful possession of the firearms. So it avoids a situation where a respondent has unlawful firearms or is not eligible to possess firearms, and it's basically prioritizing the surrender of the firearms and the immediate need for public safety over some subsequent prosecution for illegal or unlawful possession of those firearms. And then if we turn to the next page, basically the operative language that changes there is on lines 12 and 13, the respondent has the option to sell their firearms in accordance with paragraph F of that statute while they're subject to the extreme risk protection order, and then does not require the law enforcement agency to have to establish policies for disposal of abandoned firearms. The other changes on that page are basically clarifying language as well. And then if we turn to the final page, page 12 of the bill, it states it deletes sheriff and refers to law enforcement agencies in the provision that gives liability protection for mental health professionals who provide notice to the law enforcement agency. Members, that's a walk through the bill. I'm happy to answer any questions for you.
Thank you for the very thorough explanation, Senator Latz. Members, are there any questions? Senator Holmstrom.
Thank you, Madam Chair. Did we adopt the A4?
Yes, Senator Holmstrom, it was an author's amendment that we adopted. Senator Holmstrom.
Okay. Thank you, Madam Chair. Senator Latz, I spoke to you a little bit earlier about a couple amendments, so I'll just offer up the A1 amendment to start with. And
staff are passing that out.
as they pass it out, I'll say it needed a little bit of updates just because the A4 came and it was drafted to the original bill. So I'll walk through those and then explain what the amendment is after you get it.
Thank you.
All right, so this amendment is modeled after the language for orders of protection, offering another way to, another option for the owner of the firearms. Instead of just an FFL or the law enforcement to take possession, they can be given to a third party. Again, this is standard language in orders of protection. This would extend that same, so we have some congruity across the law. So the changes will be on line 1.2, where it says line 27, it's now line 11. On line 1.4, page 9, it's not line 30, it's line 17. Line 1.6, it's now referencing page 9, line 32. And then on 1.7, page 11, after line 26, insert, and then it's no longer section 9, but rather section 8. And again, this is modeled after orders of protection, offering another avenue for the now prohibited possessor to transfer firearms to a third party.
Senator Latz, your position.
Madam Chair, the original extreme risk protection order bill was assembled with a input from a variety of stakeholders, including law enforcement, and I don't have any specific input from them as to this proposed change. I'd ask if Senator Holmstrom has checked with them in preparing this amendment.
Senator Holmstrom.
I did have a brief conversation. Thank you, Madam Chair. I did have a brief conversation with the Sheriff's Association, but they did not point out anything that an official position on the amendment.
Senator Latz.
Madam Chair, is there anyone here today from the sheriffs or the chiefs that might give us some position they would have?
Is there anyone in the audience?
They've abandoned me, Madam Chair. Well, Madam Chair, I think what I would do, because the A4 amendment includes the language that was adopted in the other body, this will change that. And so I think what I'll do is I'll accept it as a friendly amendment at this time, because in principle, I'd like the opportunity to check, but since it's different than what we'll be working with the other body on, we'll have some time to consult with the stakeholders to decide which route we want to go in the final version of the law when it gets passed. I understand it's modeled after the OFP language, and so that gives me some comfort, but I don't want to make a hard and fast conclusion until I've at least had a chance to consult with those who will be dealing more directly with this. So at this time, I'm prepared to accept the A1 as a friendly amendment with that caveat.
Any other questions? So Senator Holmstrom moves the A1 amendment. All those in favor say aye.
Aye.
Any opposed? The amendment is adopted. Senator Holmstrom.
Thank you, Madam Chair. I have a second amendment to offer. This is also modeled after the OFP. So as they pass it out is the A3 amendment. I'll give a brief description.
Not a surprise that Senator Holmstrom's offering a second amendment.
We're going to clip that. So another provision that's in OFP is that while law enforcement is in possession of the firearms or of the property, that they have liability for it. That's currently not in the red flag law. It is in OFP. I think it gives, again, more consistency throughout our statutes, not as confusing to what they're liable for in their gun locker and what they're not. I also mentioned this to the Sheriff's Association. They also did not give me an official position on it. The only changes on the A3 that will have to be made with the A4 amendment that we've adopted is that on page 1, line 2, we're going to change out line 32 for line 19. Thank you.
Senator Latz.
Madam Chair, I'm thinking back to the conversations we had prior to the 2023 passage of the underlying statutes. I'm recalling that we had some conversations about concerns relating to liability. And I don't recall exactly what conclusions we had, but I think that we might have concluded at that time not to include this kind of a provision. I don't recall exactly why. I don't want to get too far ahead of myself on this one. So I think what I'm going to do is ask you not to accept the A3 amendment at this time, but that I will keep an open mind to it after I have a chance to consult with stakeholders, because I'm just concerned about imposing liability in these circumstances where there might create some issues. So I'm not saying that I object necessarily to the concept. I'm just not prepared to accept this one right now.
Senator Holmstrom.
Thank you, Madam Chair. I will still move the amendment. I think that, again, consistency and clarity for our law enforcement is a good thing.
Senator Holmstrom moves the A3 amendment. All those in favor say aye. Oh, Senator Limmer.
Senator Latz, you may recall previous discussions over the years regarding the interest of some gun owners and enthusiasts who own antique guns. Your provision in this bill would require all guns in their possession to be taken, and some of these guns, due to the finish, due to the age, due to the uniqueness or rarity, might be worth thousands of dollars. And if there was a provision that they would get their guns back, the value of those guns could be severely impaired due to an unhealthy warehousing of these guns over a period of time. I just wanted to remind you of Professor Olson, who often would talk about the collection of antique guns and enthusiasts that do that. Some guns date way back even to colonial days or the Civil War. They're historic artifacts, and the way this bill is written, that those type of weapons oftentimes just become wall hangers, but nevertheless, I would imagine they might function. Then again, there may be times when the gun might or shouldn't be fired at all, but nevertheless, they should be taken with some kind of care if they're going to be warehoused in some locker or some gun depot of a law enforcement agency.
Is there any other discussion on the amendment?
So, Madam
Senator
Chair,
Latz.
I'll just hearken back to a reference to an earlier committee hearing in which apparently there was I forget if the name was a Blaufeld. Pardon me? Senator Holmstrom had indicated there was a firearm that had the ability to, was the equivalent of an assault weapon, but it actually wasn't present in America. It was, I think, the Danish royal family that could afford to outfit their regiment with these extremely expensive firearms. So thinking of Senator Limmer's comments, yeah, if someone possessed one of those, I could see why they would want to make sure it's safely protected and ultimately returned. At this point, as I said, I'm willing to continue to give some thought to this one and consult with the stakeholders I've been in touch with on this, but at this point, I'd ask members to vote no on the amendment.
All right. So we are on the A3 amendment. Senator Holmstrom moves the A3 amendment. All those in favor say aye.
Aye.
Opposed?
No.
The motion does not prevail. Other discussion? Senator Holmstrom.
Thank you, Madam Chair. All right, Senator Latz, as I go through the A4, I'll have a few questions here. So on page 1, line 25 and 26, we're allowing the respondent to also petition the court on their own behalf, and extending actually from just chief law enforcement officer to any law enforcement officer. And I guess my question is, red flag laws already being ex parte, they already test and stretch the concept of due process, and we're dealing with a very clear right. So is there, does the value of a petitioner, or sorry, respondent petitioning on their own behalf outweigh the inherent right of the possessor? I mean, I think that filtering it through law enforcement is a more responsible way if we're taking away somebody's rights without due process.
Senator Latz.
Madam Chair and Senator Holmstrom, I disagree with the premise, I guess, that we're taking away anyone's rights without due process. The due process that is in the extreme risk protection order is exactly the same due process that's in the order for protection statutes on which you modeled your amendments, whereby an ex parte order can be issued without any input from the respondent, and then the respondent is given an absolute right to have a hearing, an evidentiary hearing later to go through that process. So in this case, what we're doing is we're expanding, and I don't think this makes any difference in terms of due process, but if you're looking at the chief law enforcement officer's agency rather than a designee, everyone within the agency could be, I suppose, designated by, say, the police chief. But this simply makes it easier from a paperwork standpoint, and also automatically gives other officers without an agency having to go through the bureaucracy of designating individual officers the authority to move expeditiously on their own as the emergency may merit it at the moment. The concept of allowing a respondent to petition on their own behalf ahead of time doesn't have anything to do with due process. If anything, it recognizes that sometimes a person may have clarity of mind to recognize that they're not in a good place and shouldn't have firearms around them, and that they need to have that outside enforcement to come in and actually do the separation and protect that person. People come at it from a different standpoint. Some people are not clear on that. Some people have a stronger affinity for the firearms in their possession than others. And this is actually not a new concept. It was around for consideration at the time that we drafted the original law, but we did not include it at that time. So this would simply give a respondent the opportunity to go to a court and say, you know what, I'm in a bad spot right now. I don't really trust myself. And I may not have a family member or close or anyone that is qualified under the law to make the petition on my behalf, but I really don't think I should have these guns in my household right now. And it's going to take me a while to get back to a place where I'm safe for myself or for the immediate family members around me. So we wanted to make sure that the subject of that protective order would have the option to go in and ask the court to issue the order to protect that person, him or herself.
Senator Holmstrom.
Thank you. Thank you, Madam Chair. Senator Latz. Okay, so moving on to Section 5 of the bill. We have, first off, I'll ask you, under the current law, how long can the extreme risk protection order be granted for?
Senator Latz.
Madam Chair, Senator Holmstrom, under current law, it's, I believe, 2 years. It could be for as little as 6 months. And then, I'm sorry, just looking at the statute here. Oh, the maximum length of an extension is 1 year. I think overall, and maybe council can correct me if I'm off, I think the maximum order itself could have been up to 2 years. But I'll stand corrected if not. But in any case, this bill provides for an extension for much longer than that if certain criteria are met.
Senator Holmstrom.
Thank you, Madam Chair. So my concern is, full disclosure, 2 years was too long for me, but when we go to 5 years, I just want to confirm this individual will not have committed a crime before this happens, correct?
Senator Latz.
Madam Chair, Senator Holmstrom, that's not necessarily correct. They might have committed a crime, and that would be factored in as one of the elements of a petition, but it's not a required element.
Senator Holmstrom.
Thank you, Madam Chair. So my concern is that 5 years is a heck of a long time for somebody to lose a constitutional right without having necessarily committed a crime. I think that is a difficult, it's going to be difficult to sell, frankly. People recognize their most basic rights in this country. And I think 5 years with no crime is really pushing the limits of what we can do. But I'll move on to Section 7, specifically lines, page 9, line 23 through 25. You had said that you included this at the request of the Chief of Police Association, and it has to do with removing the requirement of law enforcement to compensate a respondent for a fair market value of their firearms if they are permanently transferred to the law enforcement agency. And you had mentioned it's a large fiscal burden. I would agree. Guns are very expensive. Many firearms, I don't know of any really cheap firearms. So of course it is, but it should be, because we're again taking people's firearms. There's a takings clause. We should be compensating them while we're doing that. Are you married to this provision? That might not have been the best way to say that. Are you are you committed to this, or is this something you're willing to pull out of the bill?
Are you in a relationship with it?
Yeah.
Senator Latz.
Madam Chair, I was going to say my wife might have a problem with however I answer that question. I want to, if I may, Senator Holmstrom, go back to your premise of the previous question, which you moved on without asking me a follow-up, having to do with the length of an extended order for protection. You'll notice that there are two very specific criteria for going to a 5-year. But even so, there's very strict criteria for even issuing the initial one. And during the course of whatever order is issued, the respondent or subject of the order has a right every 6 months to make a request to the court to vacate that order. So it's not just the judge signs an order and it's good for 5 years or for 2 years and there's no chance to take another look at it. A respondent could make an application to vacate the order every 6 months, and the judge would have to review to see if the criteria that justified the initial issuance of the order or the extension of the order continued to remain in effect. And if the person were no longer a significant danger to himself or others, then there would not be any basis for allowing the order to continue to remain in effect. So I just wanted to make sure that's clarified. That's existing statute, by the way, and it's in the additional language also that we've added here regarding the 5-year. As to the fair market value question, I'm open to having some conversation there because, you know, there was some consideration on both sides of this issue when the original statute was passed. And I recognize that for some folks, you know, if it's if 1 or 2 firearms and they're comparatively inexpensive, this may not be that big a burden, although I understand, you know, anything is of value. And, you know, it could be an extensive collection as well, and it could contain rare items or antiques and so on. I don't know the specifics around the takings laws and what exceptions there would be to that in terms of whether or not it would actually be a constitutional taking. So that's something I'd want to take a closer look at. And I'd also want to take a closer look at the question of, just whether or not it's fair and under what circumstances. So I am willing to take a good look at that, and I would commit to working on that with you and with others and with the other stakeholders between now and when the bill comes up for further consideration.
Senator Holmstrom.
Thank you. I appreciate that. I think to your earlier point, this law was, when originally passed, had a ton of stakeholders at the table, and there was a lot of thought put into these provisions. And that provision, I'm confident, was thought through. And I don't know if it's the best idea to pull it without that larger conversation. So I look forward to having that with you. With that, that is the end of my questions. Thank you.
I'm not seeing any other questions. Senator Limmer.
Thank you, Madam Chair. Senator Latz, if I could direct you to page 2 of the delete everything amendment. And lines 229. This is when a law enforcement agency is not restricted under its legal authority to respond to exigent circumstances. Do you have a definition of what exigent circumstances would be?
Senator Latz.
Madam Chair, Senator Limmer, there are exceptions to the Fourth Amendment protection against unreasonable search and seizures for exigent circumstances, such as an emergency pursuit or imminent danger that's being posed, those kind of things. I think the idea here was to clarify that if law enforcement comes across a person and there are other legal, constitutional, because they're exigent circumstances, grounds for removing firearms from a person, that this statute could not be interpreted to interfere with the ability of law enforcement to take the action that they believe is necessary at that time to protect the safety of a person or the public.
Madam Chair.
Senator Limmer.
Thank you. Senator Latz, I have to come to a conclusion that the exigent word may be overly broad, and it would suggest a more specific circumstance or a broader definition included in that. Exigent seems like it's a very broad circumstance that could be taken advantage of. Going on to another point on page 5, and if we could go to line 26, there's a reference, we've scratched out the words "a conviction of an offense" to a history of cruelty. And how would the history be validated?
Senator Latz.
Madam Chair, Senator Limmer, that would be up to the judge reviewing the petition to determine whether and how it's been validated. There might well be police reports or calls for service or neighbor complaints, those kind of things. There might have been, other sorts of evidence that's available that never resulted in any criminal charges, or if they resulted in criminal charges, were resolved in such a way that the conviction was not for a cruelty to animal offense, but for some other criminal offense. So the idea here was just to make sure that that history, if any, is factored in as the judge is reviewing it. The judge would have to make a determination whether or not the evidence is sufficient to be reliable.
Madam Chair.
Senator Limmer.
I would also think that it could invite hearsay comments, which for lack of any other process, I suppose a judge is going to have to determine whether or not it's hearsay or if there's a little bit more substance to it. I'd be concerned about a hearsay claim in order to justify a seizure. That would be my concern in this particular portion.
Madam Chair, I'd like to direct the committee's attention to line 17 and line 19, in which existing law refers to a history of threats or acts of violence, a history of use of physical force, etc. So it's not unusual to have that context there, we at some point we have to rely on the courts to determine what's hearsay, how reliable it is, that kind of thing.
Are there any other questions?
No, I've got another one.
Okay.
Thank you, Madam Chair.
Senator Limmer.
Page 7, regarding the new language states the respondent still possesses significant danger of bodily harm to other persons by possessing a firearm. Who would determine that? Is that subsequent to a court hearing, or is that also before a court hearing would occur?
Senator Latz.
Madam Chair, Senator Limmer, that language is added to the paragraph, the sentence that starts on line 9 of that page. The court may extend the order. So it would be a court making that decision.
I missed that one. Thank you. I also had the same concern about a taking provision as Senator Holmstrom had. And I think the minor questions like that, I think I'm done. Yes, I'm finished. Thank you.
All right, Senator Kroon.
Thank you, Madam Chair. Picking up where Senator Limmer just left off on the same part of the bill of the A4, lines 710 through 712. I'm noticing that what you strike in 710 and 11 is a cross-reference to 624-7172 subdivision 2 paragraph D, and then you replace that with the respondent still poses a significant danger of bodily harm to other persons or is at a significant risk of suicide by possessing a firearm. Is the net of what you struck and what you added, does that make it easier to extend this? Because it seems to me the way it was, you'd have to go back and look at all of the elements that you initially had to prove by the state initially had to prove by clear and convincing evidence under 624-7172, and it's being replaced with something much easier to establish. Am I reading that correctly?
Senator Latz.
Madam Chair, Senator Kroon, I am looking up cross-reference right now so I can answer you accurately. The cross-reference is to the provisions for issuing that order, and subdivision 2, paragraph D, simply references clear and convincing evidence to issue an extreme risk protection order. I'm sure there's a cross-reference elsewhere in that statute to more criteria. And I believe that might be in the preceding subdivision. The basic standard, however, is what's reproduced in lines 11 and 12 there. a significant danger of bodily harm to other persons or a significant risk of suicide by possessing a firearm. So I think it's probably easier, especially given the way the other language is written, simply to reproduce the standard in writing on lines 11 and 12. But the standard hasn't changed there.
Any other questions? Senator Holmstrom.
Thank you, Madam Chair. Senator Latz, the more I sit with the bill, the more I find. I don't know if that's a good sign, but on page 5 of the A4, line 26, we changed it, or you're changing it from a conviction or an offense of cruelty to animals to just a history. Can you give me a definition of what would constitute a history, or what a court might find a history rather than a conviction?
Madam Chair,
Senator Latz.
Anything that happened before the moment of the petition would be history.
Senator Holmstrom.
How relevant it is and what it is and how far back or how recent, that's up to the court to determine how to apply that factor.
Senator Holmstrom.
Thank you, Madam Chair. So my concern is that if I find myself in this these proceedings and my friend Michael Kroon comes in and says that I didn't feed my hamster at the age of 7, that constitutes a history versus an actual conviction or offense, seems like a standard that is enforceable, and we all know what it means.
Madam Chair,
Senator Latz.
Senator Holmstrom, I'd find it hard to believe that a judge would find your hamster story significant enough to factor in. But I can tell you under the order for protection statutes, under the harassment restraining orders, those allegations of history often have absolutely nothing to do with conviction history, but they have a lot to do with allegations of conduct that gets factored in by the courts in deciding whether to issue the OFP or the HRO. No different there than here. Senator Holmstrom.
Thank you, Madam Chair. And I assure the audience I don't think I've ever owned a hamster. So. But if I did, I would feed it. Then on, let's see, I lost it here. On page 10, section 7 of the A4, line 24, this is in reference to the court issuing a search warrant to take possession of all firearms that the respondent possesses or owns, and we had changed this from in the respondent's possession. My thought is that if I have a sibling with a fire range at their home, and I happen to leave my favorite target rifle in their gun safe, and this is something that the petitioner knows, would the court be required to issue a search warrant for my sibling's home to collect the weapons there as well?
Madam Chair,
Senator Latz.
Senator Holmstrom, I would think yes, because ownership is a right to possess upon desire to do so. So that way you wouldn't leave a firearm just sitting out there, that the subject of the restrictions could simply go demand immediate possession and would then pose the immediate risk.
Senator Holmstrom.
Thank you, Madam Chair. So that's my concern, is that we're creating a situation where a seizure order may involve multiple search warrants for multiple households, disrupting who knows how many lives across the state. This seems like not a small change in the law. It seems like a pretty massive provision to change.
Senator Latz. Madam Chair, unless a firearm owner has a habit of leaving his or her guns scattered in multiple places all over their family members' estates or friends or everywhere else, it's probably not going to be that big an issue. But I can only imagine the alternative, which is the disruption to those family members or friends if the person decides to go repossess those items and having posed and continuing to pose a significant danger of harm to himself or others, uses that firearm to shoot or kill family members, neighbors, children, spouses, Seems to me that's a much bigger disruption in everyone's lives than complying with a lawful search warrant to hand over a firearm.
Senator Holmstrom.
Thank you, Madam Chair. Again, I think the scope is much wider, and I don't know your history with firearms, but I can assure you that it's not uncommon to leave a hunting rifle at a friend's deer camp in their safe where you know it's going to be safe all year, and not maybe you don't have a gun safe at your own home or shooting range of a friend's. It's not wildly uncommon to safely secure your firearms in a place where you're most likely to use them that might not be your primary residence. Thank you.
All right, I'm not seeing any further questions. Senator Latz, you have a motion?
Madam Chair, I move that Senate File 4703 as amended be recommended to pass and be re-referred to the
Senate floor.
Senate floor.
Senator Latz moves that Senate File 4703 as amended be recommended to pass and referred to the Senate floor. All those in favor say aye.
Aye.
Any opposed?
No.
Motion prevails and it is sent to the Senate floor. Thank you, Senator Latz. We're going to move to Senate File 4474. Senator Rasmusson.
Senator Rasmusson, we have your bill here. We do have amendments as well. This is the second committee this bill has come to, so we'll need to have the amendment explained. So why don't you go ahead and just tell us what your bill is about, and we'll consider your amendment.
Thank you, Mr. Chair. I appreciate the opportunity for the hearing. Minnesota, like many states, allows sweepstakes as a promotional marketing tool. One example would be the McDonald's Monopoly game, where if you buy a hamburger, you get a chance to win something. We have seen, unfortunately, Mr. Chair, that online companies are using Minnesota's sweepstakes laws to effectively offer online gambling. They use what's called a dual currency system, where consumers can buy gold coins, which is like getting the hamburger, and they will get these bonus sweep coins as a part of that, which they can then play online slot, online roulette to win real cash prizes. Effectively, this is online gambling where there's consideration, a game of chance, and a prize at stake. The bill before the committee would clearly ban these dual currency online sweepstakes casinos, joining a number of states that are having to update their laws. This would not ban any social casino games, and I'll just quickly reference there's a broad coalition of groups that are supporting this bill, everyone from the Minnesota Family Council and Catholic Conference and Citizens Against Gambling Expansion to some of the organizations that have either charitable gambling or other forms of gambling here in the state of Minnesota. The A1 amendment is based off of feedback that we received from the Department of Public Safety on making sure that we have proper enforcement and are clear about enforcement authority for this prohibition on the newly defined online sweepstakes games.
Mr. Chair, I'll move the A1 amendment.
Any discussion on the A1 amendment? Not seeing any. Senator Limmer moves adoption of the A1 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Members, this comes to us from Commerce, the substantive committee. Let's please focus on the penalty provisions, which we just adopted. Is there any discussion on the Senate file as amended? Not seeing any. The motion is to send this to state and local. Senator Limmer Move Senate file. Oh, I'm sorry. Senator Westrom, you have a question?
I do, Mr. Chair.
Senator Westrom.
Senator Rasmusson, I'm just trying to get the breadth of the bill and what it all affects as far as businesses, and it seems like there's a lot of unique or technologically advanced systems that aren't gambling, but are creative with today's technology. And where do we draw the line between them and gambling? And I guess give me a little more understanding of who's pushing this bill.
Senator Rasmusson.
Thank you, Mr. Chair. Thank you, Senator Westrom. So the bill is narrowly defined for these dual currency online sweepstakes games. So it would require consideration. It would require a casino style game or other form of gambling. And then there would have to be a prize that is available for the person who is offering consideration to win. And that's typically how we think about what is gambling or what is not gambling. There are a whole host of other sweepstakes that will not be affected at all by this bill. For example, I asked McDonald's to review this language to see if it would impact their Monopoly game. It does not. If you're running a traditional social casino, which is playing for free, playing a blackjack or roulette, you would also not be affected. And I also asked the electronic basically game association, the video game association, to review this bill, and they and their members also did not have concerns. The only individuals who have brought forth concerns are the online sweepstakes casinos that would be banned and prohibited in this bill.
And Senator Mr. Chair, Senator Rasmussen, an online casino sweepstakes, can you explain them a little bit more? Are they offering money, or when you say there has to be a prize, could it be a big stuffed animal like it is at the fair, or does it have to be cash or monetary consideration?
Senator Rasmussen.
Yes. So, Mr. Chair and Senator Westrom, we use the definition of prize that is already in statute under the consumer protection laws. And so in this bill, a prize would mean a gift award or other item or service of value that is offered or awarded to a participant in a real or purported contest, competition, sweepstakes, puzzle, drawing, scheme, plan, or other selection process. So anything that meets that definition would be considered a prize in this bill, and that has been a longstanding definition as we've looked at these types of lotteries, sweepstakes, or other contests.
Is there any further discussion of the enforcement provision?
Mr. Chair.
Senator Westrom?
Mr. Chair.
To the enforcement provision, please.
Say that again, Mr. Chair. Sorry.
To the enforcement provision within this committee's jurisdiction, please, Senator Westrom.
Well, Mr. Chair, I guess what I'm still a little perplexed on or confused is where the line is drawn or going to be drawn. Senator Rasmusson, you talked about McDonald's, and some of those sweepstakes would not be swept up in this. Who would, and what defines, where's the bright line of why they wouldn't be, and who is? Because I've had some talk to me about concerns of this with not really prizes or money that's being paid out, but they're concerned that it would affect them, and so that's what I'm trying to get a grasp of.
Senator Rasmusson.
Thank you, Mr. Chair. Thank you, Senator Westrom. So again, to fit the definition of an online sweepstakes game that would be prohibited in this bill, there has to be consideration. A dual currency system needs to be used. There has to be a casino-style game or other form of gambling, and there has to be a prize as defined in statute. And so all of those criteria have to be satisfied, which is why this is a narrowly constructed definition. And for legitimate promotional sweepstakes, for other types of social casinos, other video games that perhaps offer prizes and even different things that individuals have to buy, when they have reviewed the language, they haven't expressed concern. The only groups that have expressed concern to me are those who are running sweepstakes casinos, which we are trying to ban in this bill.
alert.
Thank you.
Seeing no further discussion, Senator Limmer moves that Senator Senator Holmstrom. We have 2 or 3 more bills to get to in the next 10 minutes. So I'll move to Senator Coleman, who's been waiting patiently. So
I'll pass.
all right. Senator Limmer moves that Senate File 4474 as amended be recommended to pass and be referred to the Senate Committee on State and Local Government. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, Senator Rasmusson. Senator Aaron Maye Quade, and then Senator Coleman with the Senate File 4602. Senator Aaron Maye Quade. Find the Senate File number 4379.
Thank you, Mr. Chair and members. You're not going to get a lot of Maye Quade Drazkowski bills before you, but here is one. This is a comprehensive framework for how NDAs at municipalities can go. There are specific circumstances under which NDAs cannot be entered into. We've done a lot of work to incorporate feedback, and there is an A6 amendment that has exempts municipal power agencies and clarifies the definition even more so that agenda items on municipalities' agendas before the City Council, that is what's not allowed by an NDA, not just seeking information. Mr. Chair, that is my bill.
Senator Maye Quade, I understand you have an A6 amendment.
Yes, Mr. Chair.
What is that about?
This adds in the exemption for the municipal power agencies, especially those that are formed under the laws of another state besides Minnesota, and it lays out the specific provisions or the specific instances when a municipality cannot enter into an NDA. So development of land, economic development project or program that's on an agenda of the municipality, or a project or program that's financed with tax revenues or money from the city or taxpayers.
And they would fall within the enforcement provisions or be subject to the enforcement provisions, is that correct?
Mr. Chair, I believe the part of your committee is that this is about NDAs for municipalities. There's no enforcement provision above and beyond just not entering into NDAs.
Any discussion about the A6 amendment? Seeing none, Senator Pappas moves adoption of the A6 amendment. All those in favor say aye. 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 Opposed? Motion prevails. The amendment is adopted. Discussion from members of the Committee on the Enforcement Provision on lines 20 and 21, page 1 of the bill. Not seeing any discussion. Senator Pappas moves that Senate File 4379 as amended be recommended to pass and be re-referred to the Senate floor. All those in favor say aye. 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 Opposed? No. Motion prevails.
Thank you, Mr. Chair.
Thank you. Senator Coleman, thank you for being patient today. We're going to take up Senate File 4602. Members, the intent is to lay this bill over. We're going to take Senator Coleman's description of the bill, which is being handed out. Senator, why don't you go ahead and tell us the bill while we catch up with the paperwork here.
Thank you, Mr. Chair. The way this bill got to me was actually probably one of the most interesting routes I've had in my 6-year tenure here in the Senate. One of those things where it's an evening and you're scrolling Instagram and I come across my good friend here from high school's story about, which was rather terrifying, about dealing with a stalker and kind of some of the gaps that she found in the system, one of which being she requested notice when a protection order was going to be issued so she could remove her and her children from the home and did not receive that. But rather than, and so this bill just requests that law enforcement agencies make reasonable efforts to notify somebody 24 hours or before this order is issued. But I would like to turn it over to her to tell her story, if you wouldn't mind, Mr. Chair.
Thank you, Senator Coleman. And ma'am, I have your name down here as Dominique.
Yes.
Go right ahead. Tell us your story. Just keep in mind we have about 6 minutes before we are required to adjourn.
Okay. Thank you, Mr. Chair. One morning in late 2024, I logged into my work computer and saw a collection of emails from an unfamiliar name. At first glance, I thought these messages were AI spam, but as I began to read them, I realized that they were deeply personal emails that included information on my family, my work experience, my name, and my ancestry. The aggressor, who is a Minnesota resident, had found me on LinkedIn and singled me out as one of few women with my job experience to be able to build a secret society. His emails contained thousands of words, over 80 photo attachments, and videos of himself. One of the attachments included a photo of me with my child alongside a similar photo of himself with a baby, and others included photos of himself at important places in my life, like the church where I was married and the school that I went to. Most concerningly, he made references to my infant son and claimed that he had a crib and a baby carriage at his home prepared for my son. In one of the videos, he discussed that he had 2 women picked out to offer my husband in exchange for me. I continued to receive additional concerning emails after this, so I filed a harassment restraining order. And after it was granted, I quickly called the courts and eventually law enforcement to find out when the restraining order would be served. It was a Friday, and I was told that there wouldn't be time to serve it yet that day, and that it would likely be served over the weekend or the next week when notification of service does not occur. I called and asked at length to see if there was a way that I could be notified, and someone let me know that while that isn't their typical protocol, that they would give me a special number to call. I called it each day and did not receive a return call. Several days later, I found out that the order had in fact been served on Friday afternoon, and I had not had the opportunity to remove myself and my children from my home. I was very concerned about retaliation from this individual, and while I was incredibly glad that me and my family were safe, I burst out in tears knowing that I had put my children in danger over the weekend. The passage of this bill is important to me because it would allow victims the notice and opportunity to protect themselves and their families during the service of a harassment restraining order. And I know that petitioners spend immense time deciding whether this is the safest route for them. So we want to make sure that people have the ability to make decisions to keep themselves and their families safe. This bill would provide comfort for victims already experiencing a terrible time in their lives. Thank you for listening.
Thank you for coming forward and sharing your story with us here today.
Thank you.
Glad you're all safe. Any discussion by members of the committee? Senator Holmstrom.
Thank you, Mr. Chair. Senator Coleman, is there any concern that this may delay the issuance of these orders that might create more danger?
Senator Coleman.
Thank you, Mr. Chair. Thank you for the question. I have not heard of any concerns regarding that at this time.
Senator Holmstrom.
Thank you, Mr. Chair. That's all I have.
Any other discussion? Senator Coleman, if you want to discuss, speak up so we hear it on the record. Senator Westlin says it's a good bill. Senator Coleman, we have the option. We could lay it over, or we could send it to the Senate floor if you wish, and talk about how you'd like to get it passed at that time. What would you like to do?
Thank you, Mr. Chair. To a previous point being that I'm not in the majority and can't control necessarily what comes to the floor, I'll leave it to your discretion.
Well, members, I think we're going to send this bill to the floor, and we'll have further conversations about how to proceed from there. Fair enough? Senator Limmer moves that Senate File 4602 be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Okay, hold on. Don't go anywhere quite yet. You can leave, Senator Coleman. Okay, Senator Seeberger, having been on the prevailing side by which Senate File 4206 was passed, moves to reconsider the bill. All those in favor say aye. Opposed? Motion prevails. Senate File 4206 is in front of us. Senator Seeberger moves to send Senate File 46, be recommended to pass and be referred to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. All right, members, we have made our 5 o'clock deadline. Thank you all for your work today. I don't think we have anything else left at the moment to do. We will return April 8th, Wednesday, for our next committee hearing at its regularly scheduled time and location. I wish you all happy holidays, a spring break. Whatever you have going on, be well rested. It'll be a sprint to the end. We are adjourned.